For the reasons assigned, the notice cannot be held to be illegal, and therefore this requisition is dismissed. But before parting with the records, I made an observation that this judgment would not come in the way of the government to consider representation, if any, submitted by the petitioner number 1 for an alternative land, which shall be considered either positively or otherwise in its own merit without being influenced by this order and without treating this observation as a direction of the court.
So obliged.
Yes, yes.
I am mentioning one item, my lord. For last 1 year, it has been mostly not.
Prayer for listening, please give it to the court master. He will have to make some adjustments.
Where money?
In the court master, the court, second person, he will have to make some adjustments.
I need to mention item number 40 in admission
40.
for 40.
Yes.
Yesterday I filed the additional affidavit, my lord. So
Okay.
some time may be granted.
You want some other day?
And
Okay. Let this matter be listed in the next week along with the affidavit filed by the petitioner. Okay,
my in time order is there.
okay. Interim order passed release and extended till the next date of listing. You have informed the other side? Have you informed the CGT?
No, I have not seen him.
No, then wait. Without consent, I am not adjourning. Item 40.
44. I may be.
Okay.
I mentioned item 5 and 19. My senior has some difficulties, so this matter may be taken at 2 PM.
Item 5 and
5 and 19 euro.
5 and 19.
May be
Okay.
taken at 2 PM.
Okay. 5 and 19.
Yeah, yeah, Lord.
Just a minute. Yes.
May I please your lordship in item number 53 of the supplementary cause list lordship, the petitioner has filed the additional affidavit yesterday. So kindly it may be taken to the record lordship.
You call it. Give a slip to call it. Otherwise, it can't be tagged. I would not go to the registry, bring the record and tag it. Correct. That you will have to do.
Much obliged.
Give a slip.
May I please, your lordship? Lord, I beg to mention item number 45. In this case, Lord, steps you have taken, Lord, but due to incorrect address, Lord, the same return answer, Lord. So I have to take fresh steps, Lord, and at the same time, I may be allowed to put the correct address.
Okay. Both sides have been represented. The Grand Council for the petitioner submits that the steps taken on the private respondent has returned back on the ground of incorrect address. So the Grand Council for the petitioner raised and is permitted to bring the correct address of the private respondent on record and to take steps for service of notice. To take steps within how much time will do it? Correction?
Lord, within this week, Lord.
Achha, the petition shall take steps within a week.
If I am allowed to,
For
Lord,
service.
correct the same in presence of the registry.
That will do.
Yeah.
Correction shall be in the presence of registrar judiciary. The petitioner shall take steps within a week for service of notice on the private respondent by registered post with lady. Notice is made return number for 5 weeks, list accordingly.
Obliged.
Please, your lordship,
Yes,
I'd like to mention item number 20 of daily use.
yes,
Which is, matter relates to challenge made with regard to allotment of certain guidelines by Gwalpara Municipal Board.
yes.
The senior is not well, matter may be taken up some other time.
The private respondents, you have taken consent? Okay, with consent of the other side, Miss. Your name?
Be Decca, lordship.
D. Decca, appearing on behalf of council for the petition of place for adjournment. There is your list after week as paid for. Okay,
Wait, please, your lordship, lordship, with consent from the other party, I beg to mention item number 23. Matter may be adjourned for the day.
Well, I am not a petitioner, madam. They pay for date, madam. Any date.
okay,
Matter may be fixed after 2 weeks, your lordship.
okay. Both sides are represented on the plan made by council for
And Kalita, your lordship,
for
for the forest department.
the forest department, matter stands adjourned today. List on so and so. Is there an interim order?
No interim, madam.
Okay.
Any date, madam.
Give it six.
Highly obliged.
Obliged.
May I please, your lordship?
Yes,
Item number 14 and 18, your lordship, can be passable for the day, your lordship.
14 and 18.
Yes, your lordship.
Okay, 14, 18. Pass for the day is paid for by non-council petitioner.
Obliged, your lordship.
Daily list item number 1 and 2 for Masala.
May please, your lordship.
You have instructions?
Madam, kindly be passed over for a time being.
Just a minute.
But the petitioners are in the forest land, my lord. They are not in the my lord, so the my lord, acquisition of their land does not arise, my lord.
After some time,
File
then,
affidavit.
after some time, it's needed.
Yes, lord.
Okay.
Obliged, lordship.
3,
May I please, your lordships. My lord,
I'm issuing a notice at this stage.
Lord.
Also notice on the prayer for interim relief. Mr. R. Sharma and counsel for the petitioner. And Mr. K. Govel, government advocate appearing for respondent numbers
2, 3, and 4, lordship.
2, 3, and 4, and 1 you are appearing, and Ms. G. Azarikal, government advocate appearing for respondent number 1. Issue notice, including notice on the prayer for interim relief, return of a loan so and so.
4 weeks.
Extra copies for 1 to 4. Steps by registered post will vary within 2 days for private respondent numbers 5, 6, and 7. List after 4 weeks.
Lordship, lordship.
lordship, till such time, lordship, status quo,
No, it can't be given for the, there are reasons for that. Because you see. There is
I
absolutely,
am
no,
still
no,
in possession, lordship.
no, that's okay, but there is no clarity of, when you applied, when did you make an application?
That application
What,
is,
when did you pursue it?
that application is annexed, lordships. This application, page 33, lordships. I have filed the application before the deputy commissioner for ownership rights, lordships. NNC case number 101 of 2021, lordships.
No, you see, this list requires an adjudication because you have said in page, that page 34. That issue notice to the concerned landowners and to other co-tenants and the scheduled land who have been included. So therefore, it requires an adjudication. Now, what is the stage of that adjudication? We don't know. But you can get an information about this case.
About it, lordship, regarding status of the lordship, the tenancy.
It is,
Lordship, lordship.
so instead of long term, we are giving it 3 weeks,
Lordship, lordship, lordship,
make it 3 weeks.
lordship.
But take steps within the course of the day
Lordship.
for the private respondents. Just right, in the meanwhile, the government advocate shall obtain instructions from the Office of the Deputy Commissioner, Kanpur Metro, regarding the status of tenancy case number 101 of 2021. Then we give them an interim protection till then not to evict till it is disposed of. Mr. Gogoi,
Also regarding outcome, he deferred that particular tenancy case lordship. My lord, may kindly press page 40 lordship, pair person lordship.
yes,
The first price settle the land to the petitioner as described below, so under section.
no, that is the requirement
And certificate of ownership under section 26 4 lordship.
because it needs, has to be entered in the record of rights and it has to
My lord,
be.
may status quo is on to the lordship.
Oh, okay. Until, and in the event the state tenancy case number 101 of 2021 has not been disposed of, then the status quo in respect of the land be maintained till the next date of listing. So the continuation of interim order would be subject to further orders that may be passed on the next date.
For
Mr. Sharma, what is the date of the tenancy case? 8/12/21.
21.
8/12/21. Date is right?
Lordships.
Yeah, tenancy is also filed on 8/12/21. Okay. Yes, item 4 you want to pass over.
Lordship, in this matter, Lordship, on the last occasion, the respondent was directed to take instructions.
Yes,
I am obtaining for the state of Mizoram on behalf of the AG.
yes,
Well, I have written instruction that they can be accommodated.
they can be accommodated.
I have,
So, okay.
that
please
is
pass it on.
subject to permission from the Assam government.
Okay, so the travel arrangement you have to make if the state of Mizoram has no objection. You give a copy to him.
Yes,
to-
yes.
To Mr. Gogoi, let him take instructions at 2 o'clock, we'll take it up. Mr. Gogoi, you can get it today or you want some other day,
My lord, may next witness, next,
next Wednesday,
in the meantime, I will obtain instruction regarding this.
okay.
That's fine.
Mr. A. Chakravarti, counsel for the petitioner. For Union, Mr. Gogoi, you will appear for Union of India also.
I will appear in my brother for state lordship.
Oh, okay, Mr. K. Gogoi, and CEC appears for the respond number petitioners, as petitioners. For respond number 1, Mr. You are appearing,
Yes, sir.
Mr. A. Kavita, and additional AG for respond number 2.
So as for 6 to 8.
I am for 1 and 2 lord.
Oh, sorry, you'll be for 1 and 2, okay, all right, 1 and 2. Additional AG for respondent numbers
6 to 8 lordships.
6 to 8. And Mr. M. Shetial and the government advocate appearing for respondent numbers 3, 4 and 5. Next paragraph. Pursuant to order dated 3/5/2023, the learned additional AG for the state of Mizoram has produced a copy of instructions received by him, wherein the state of Mizoram does not have any objection for the
Lordship, I'm sending that
Ah.
instruction.
for providing shelter to the 17 petitioners subject to the no, only transfer 17 petitioners who are currently lodged in the detention center Gwalpara, Assam. As there are 164 relief camps presently within the state of Mizoram for Myanmar refugees. The said instructions received from the Undersecretary to the Government of Mizoram, Department of Home is dated 12/5/2023 is kept as a part of the record. Next slide. Mr. K. Gogol and
Lordship, my
CEC,
brother will protest.
no, both of you,
Lordship,
CEC, learned CEC, as well as the learned government advocate shall obtain instructions regarding the manner of transporting.
Facilitate the transport.
Facilitating the transportation of the, for the petitioners from the detention center at Gwalpara to the state of Mizoram.
State of Mizoram. Aizawl, state of Mizoram.
Aizawl in the state of Mizoram. Next para. List on Wednesday. List on
7/6.
Lordship, if the witness, Lordship, may on ideal Lordship, then it will be.
okay, no problem. 19.
Lordship,
Next para, the learned CGC and learned government advocate is permitted to send a downloaded copy of this order to the concerned authorities to obtain instructions.
But I prefer copy of the repetition Lordship.
Give him a copy. Give him a copy. It will be easier for him to communicate. Give a copy.
6.
19/6. Can only give a notice at this
Lordship,
stage.
in
We
this
can't
case,
give you.
as per my lord's direction, I have obtained instruction. Lordship.
Yes, yes.
Lordship, it is under process, but my lord may kindly pay with the inspection.
We'll issue a notice.
Otherwise also, Lordship may issue notice and we have
Your
other
lordship
process
will
for
issue
issuance of a that's Lordship license. also.
Your lordship can dispose of madam order to take action in terms of the PIL order. That's all.
My lord, in para-wise reply in paragraph 12 and 13, Lordship. 13 it says that Lordship, license will be issued shortly. The matter was discussed on 27/4/2023 and discussion minutes awaited, Lordship.
Then my
So,
lord,
Lordship, on the basis of that, my lord may dispose of also, Lordship.
or your lordship.
Okay,
may take-
because if I'm disposing it of in the motion stage, I'll have to record your.
Lordship, on the
Submission.
basis of that instruction, my lord may kept in record also, part of the record also.
Okay. Heard Mr. R.P. Sharma, then a senior counsel, assisted by Mr. N.K. Kalita, learned counsel for the petitioner. Oh, sorry, D. Dole, I'm sorry. Learned government advocate, sorry, learned counsel for the petitioner. And Mr. K. Gogol, learned. Your designation is additional senior government advocate.
Lordship,
Okay.
Lordship.
So additional senior government advocate actually for the respondents.
Lordship.
In the earlier order also, make, he's appealing for government and additional senior government. Next one. The case of the petitioner, comma, in brief, comma, is that pursuant to, in terms of the interim order dated 12/12/2021, passed by this court in PIL number 79 of 2021, comma, the petitioner has applied for license to deal with Schedule X items under the under Rule 4 within bracket 3 of the Assam Minor Mineral Concession Rules for 2013. Give the date of it. He has applied on 17/1/2023 for license assurance by the Department of Mines. However, the application submitted by the petitioner has not yet been disposed of by the Department of Mines and Minerals, Assam. Accordingly, the petitioner has approached this court for an appropriate direction. And approach this court under Article 226 of the Constitution of India for an appropriate direction. Next, pursuant to order dated 19/5/2023, the learned additional senior government advocate has produced otherwise comments along with forwarding letter dated 29/5/2023 issued by the Director of Geology and Mining Assam And in paragraph 12 and 13 thereof, it has been mentioned that inverted commas, no objection, bracket closed, has been granted for transportation of low-grade limestone as ex scheduled minor minerals by the then director as competent authority. And that licenses would be issued shortly. And that the matter was discussed on 27/4/2023, and the discussion minutes are awaited. Full stop. Next, one, in terms of the said Paravas comments, the learned absence in economic advocate has no objection if the writ petition is disposed of with the direction to the Director of Geology and Mining assigned within bracket respondent number,
Respondent number 3 lordship.
respondent three,
Director is 2 lordship.
to take an appropriate decision as per the Paravas comments within an outer period of 15 days
Lordship.
from the date of receipt or certified copy of the order. First, following this, the decision stands. Allowed to the extent as indicated above.
My lord may get a part of the record lordship.
Sorry, the forwarding letter dated 29/5/2023 by the Director of Geology and Mining Assam, along with the Paravas comments and a copy of Gazette notification dated 3/3/2022 is retained as a part of record.
Lordship. Oblige, lordship.
7,
May I please, lordship?
Yes,
This is the 227 application.
But-
There are two
no, there are many issues. Number one, if it is 227, it has to be re-registered not as a writ petition.
Yes.
Number one. Second is,
Now, here the issue is a bit with regard to the,
is,
uh,
I'll to tell you.
jurisdiction part is also, that is why I have. come to that.
Jurisdiction is not there. I'll tell you why.
That is why. Because of the subsequent again amendment, the problem now arises. Because that part has to be dealt with.
If there is an amendment, I don't know of.
There is an amendment in the Companies Act under which it has been filed. What has happened, your lordship, just.
What is the amendment?
The amendment has now, this was filed under section 452. Initially, it was 630 under the earlier act of 1956. So that was amended. So 2013 act came. 2013, the same issue with regard to
452.
withholding of property is 450. Now 452. In view of 450.
This,
I'll let you-
you see, this is a subordinate jurisdiction under Article 227.
Lordship.
Next page, you will find Companies Act is not under the supervisory jurisdiction of this court, number one.
Yes.
Number two is that there is a difference between the language used in section 630 of the Companies Act
Mhm.
and 452 of the 2013 Act.
Yes.
The 630, section 630 of the old Act, 1956, said that if anybody retained possession illegally, and in 542, 452, retention is not there. It says that one who occupies a property illegally.
Yes.
So if a workman is occupying a lawfully and then retains it unlawfully.
So
I
that
don't-
is the case. My case is that because of that we have filed it under 452.
Hmm.
Now, problem is not that. Problem actually what has happened for 435. Under 435, this matter was filed with 452 before the.
It will come before the jurisdiction magistrate party.
He says that he doesn't have a jurisdiction.
Correct.
He sent it to the special, which was
Correct.
constituted under 435.
Correct.
Now in 2018, that was amended, which came into effect in 2021. Now that 452 has been exempt. Now what happens to us? That is why I'm coming before. That is the problem. I'll just show that before going into all this, and just give a copy of that. Take, kindly copy to lordship.
Then the
I am a
answer
little
is,
bit handicapped, my
no,
junior.
it's okay, it's okay. Then the answer is very simple. You have to file an ejectment suit.
No, what it has done. It is made this that 435 says, I'm giving a copy of,
Companies Act.
that is the Companies Act 2013. I have a printout of that.
Okay, no, not required.
Establishment of special courts, your lordship.
Yes,
Central government may, for the purpose of providing speedy trial of offences under the act, except under section 452 by notification, establish or designate as many a special court as may be necessary. Now, this substitution, your lordship, will see down reference effective from substituted by the Companies Amendment Act 2017 with effect from 7/5/2018 dated 7/5/2018. Now, this 452 has come in except under 450. Earlier it was not there. That has created the problem. And the in 452, the other, your lordship will find the other section 452 also. Here, your lordship, the
no,
second part
where is that? Except 452, where is that?
in the 435 itself, 435 section. Lordship will see 435. This was substituted by the Amendment Act of 2017. The central government may, for the purpose of providing speedy trial of offences under this act, except under section 450. Now, 452 should, because whether it will be by the special court, will go back to the original. That is where the issue remains. This was amended. And the amendment was effective from 7/5/2018.
Okay, so you are trying to say that this will go back to the magistrate, jurisdictional
That
magistrate
is
at
where
Divugad.
I am also not very sure, your lordship, because two things, because this is a special court which was constituted for all these matters under the company, number one. Now, what has happened? It was sent by from the Divrugarh court here. That till then we don't have a problem. Now, this amendment has again changed the whole scenario by saying that except 450. Since this is 452, should it go back to that?
No, but that's what you see, that's why I'm saying that the problem is not only that. But if 452 does not provide for illegal retention of the property, then it will be without jurisdiction.
No, that, which one? With 450, let me read the 452.
Yes.
I have given that also. Punishment for wrongful withholding of profit. I have given that also. If any officer or employee of a company wrongfully obtains possession of any property, including cash of the company, having any such property, including cash in his possession, wrongfully withhold it or knowingly applies it for the purpose other than those expressed or directed in the articles and authorized by this act, he shall, on the complaint of the company or a many member or creditor or contributory thereof, be punishable with fine, shall not be less than 1 lakh, but may extend to 5 lakhs rupees. So that was earlier it was 10,000. Now it has been made to 1 lakh to 5 lakhs. The court trying an offence under subsection may also order
So
such.
therefore, you
officer-
see, the first requirement of 452 is A, wrongfully obtains possession of any
Yes,
property.
Exactly.
So it is a departure from 630 where it says that illegal retention of the property.
Yes, that was also in, I didn't bring that judgment. There's a judgment subsequently which says that the earlier 630, the basis essence is still there in this case. Anybody who is holding it wrongfully or withholding it wrongfully a property, a person who is not in the company or still in the company but withholding it wrongfully, he is entitled to be trial under 450. I can bring the judgment if I get some time, because I got it that day.
At 2 o'clock then, because this is a point I'm not satisfied.
Because this part with regard to 452, that the court will decide whether it is satisfied or not. This court is basically with regard to jurisdiction, because that is the point. Even if your lordship decide, because ultimately the court in trial court will decide whether the withholding is illegal or 452 is expressly
right.
followed or not.
You are right.
But 435, how?
Okay, still
we'll
we'll take it up
overcome
at, still we'll take it up at 2 o'clock. Let me have the registry's view.
Yes. 435 is the issue, your lordship, now.
Okay, I get it. Okay. At 2 o'clock, let me
Right.
do that research.
That's I'll also try to get the judgment.
It's okay because you are otherwise right.
Yes.
We will not displace you in this writ petition.
Yes.
I will not do that. I
Because
got ca-
435, if something can be done, whether it
times-
goes back or it remains, that is the only issue.
At times I get carried away.
Parts of life. Hey, kitab, come. Lordship's book is here.
So you see that superintendent is not there. Otherwise also we'll have to direct you to re-register it as a
So two,
226.
that can be converted.
It can be converted, but superintendent jurisdiction is not there.
That is not here. See, much of-
Okay.
Yes.
that is a law. Yesterday, Lordship has had this matter
Yes.
at length, Malak.
Wait, take it up at 2 o'clock. Let me finish the motions and then take it up. This, what you call, your reply in yesterday's matter. Okay. Other matters will be deferred, but yesterday's matter will take it up.
Malak, there are other connected matters,
I
similar.
know,
matters.
but those will be adjourned because I can't take up all these matters and take it up. But if that one matter is heard,
Yes, Malak.
the same ratio will follow in other cases. Huh.
Public.
At 2 o'clock, because I want to dispose of the motions first.
9.
Wait, please, Your Lordship.
Mr. Chaudhary, what are other matters in the list? Tell it to the court master so that he can take out those files. Huh. Just tell him, the court master. Okay, we'll issue notice.
My lord, for simple prayer, my lord, that a representative was submitted on 22. That may be the, my lord,
I'll,
disposal.
no, I'll do it.
Harvest going to be expired on 36.
Mr. FKR Ahmed, counsel for the petitioner.
Panchayat
PNRD, who is appearing?
Panchayat and Rural Development.
Nobody there.
As
What's this? This PNRD, SCPNRD. So this order has to be passed in his presence. After some time,
Yes, sir.
we'll try to get him. So this order must come in his
Yes,
presence.
my lord.
Otherwise, this inquiry will not be made.
Yes, sir. These are all simple prayer. As far as the next item is concerned, in this matter also, may issue notice because there is a conflict. My lord, my vehicle has been
No,
seized.
this item 10, we can't issue an order because this will be, I think it will be dismissed. The reason is, you are saying that for a forest offense, who's appearing for forest? You are there? Mr. Pathak, you are appearing for forest?
I believe this is
10,
a
item 10.
transferred subject, but otherwise I can represent the respondent number 1, the piece.
Okay, so you see what has happened in your case, because of the forest offense, your tractor was seized,
Yes, ma'am.
correct? So, prosecution for a forest offense is before the jurisdictional magistrate, correct? So therefore, number 1, petition for Zimma will not be entertained by the High Court. That is one, because there are other provisions in the CRPC to deal with issue of Zimma. Custody petition must be elsewhere in the jurisdictional court.
As well as under the forest regulations.
No, no, they are
No.
not-
There is a separate procedure laid
No,
down.
no,
for
why-
custody.
No, I understand, but it will be
Yes.
the jurisdictional magistrate
Yes,
only.
yes,
The
yes.
DFO will not
Before
have, he is not vested with the power.
But the confiscation process has not yet been initiated by that, even after lapse of 1 year.
It may not have done. You see, let us say in a theft case, some matter has been seized, some item has been seized, no case has been registered or the progress is not been made. So a person whose vehicle was stolen or whose property was stolen, can't he go and apply for Zimma?
When we made this about representation to them, I
Oh,
know.
representation is okay, you give on going.
This is my only source.
We
of
will,
livelihood.
we'll give you a 10-year lease.
My lord, what is the seize, my lord?
No, Mr. Ahmed, you see, we have to deal with the matter legally.
Fine.
Even if I give you a pata for 10 years to write representation, nothing is going to happen. You'll have to apply before the magistrate and under the jurisdiction he has. Now see, item is seized by the police. Instead of 451, 457 Zimma petition, you try giving representations to everyone from governor to the chief minister. Will something happen? If the jurisdiction is on the magistrate, it will be only he. Others will not have jurisdiction.
Well, no cases yet been registered, my lord, on which case we seek, my lord, the custody. We file an application.
No, no, if there is a seizure, there is always be a, a seizure list. You can apply on that basis.
Seizure list, yes, we will get seizure list in this case. We annexed the seizure list in the.
So on that basis, you file, the CJM will himself find it out where it is. So this will not be maintainable. I'll have to dismiss it. Rather, we'll close it with an observation.
My lord, I will do my lord, totally, but my lord, we approach.
Okay, okay. Heard Mr. FKR Ahmed and counsel for the petitioner. Mr. K.V. Pathak Lanet, standing counsel for the Forest Department, appearing for respondent number 1. Mr. Nayak, you are there? Oh, sorry, this is Difu Karbi Anglong. You will be there.
My lord, there is a provision is there, my lord.
That's what I'm closing it.
Yes,
That's
my
why. And Mr. I just wanted to record your presence.
My lord.
Mr. J. Sujal Lanet, standing counsel for Karbi Anglong Autonomous Council, appearing for respondent numbers
4, 2, 3,
2
4,
to 5.
5.
2 to 5 all.
2 to 5.
2 to 5. Next para. On the ground that efficacious alternative remedy lies in filing an application before the jurisdictional magistrate, the learned counsel for the petitioner seeks to withdraw this petition with liberty to approach the jurisdictional court.
Right.
So, if prayer is allowed, the matter stands dismissed from withdrawal with liberty as prayed for. Mr. Nayak, we'll have to issue a notice and state because if the
Lordship may
license
not like to stay
tenure-
Lordship, because it's a tender of 2021 Lordship. And today morning I have been told that they have already settled the Mohal, but the actual settlement order not yet been furnished to me. So Lordship will take up this matter after 1 week Lordship. In the meantime, I will furnish instruction.
I made a statement that there is no formal order because this is my third round of litigation, my lord. Your
you can try
lordship-
to get it by 2 o'clock if there is an order, because if they manufacture order now, that will be difficult.
No, that is not, that will not be there. In the morning itself, they informed me that it has already been settled. But as the settlement order is, a tender order was of 2021 Lordship. So they are looking for the file Lordship.
My lord,
Acha.
Lordship may take up this matter on Friday also, Lordship.
Instead of Friday, we can take it up tomorrow because Friday,
Lordship.
Friday
Tomorrow,
will-
if it is settled, Lordship.
because Friday I have a lot of matters.
Lordship.
tomorrow, my lord,
Lordship may
then
take up.
tomorrow 2 o'clock, my lord.
Lordship.
Tomorrow. Okay. Because it's this, because if it is a case of trade license, which is not renewed, that is not,
Labor license.
labor license, which is not renewed, that will not be fatal.
No, at the time of, on the last date of submission of the tender Lordship, his labor license was not valid.
No, no. You see, for example, a trade license. GMC issues a trade license. X has a trade license, but it is not renewed. So yes, for that you can take coercive steps, but that will not ipso facto make the license inoperative.
Lordship.
By operation of law, a labor license or a license, GMC trade license or any other license will just, or a drug license for a pharmacy will not lapse because of the non-renewal. You may take coercive steps to close down the unit.
Lordship will consider that issue, Lordship.
Ah.
Let me
Okay,
have my
okay.
instruction by.
No, because that is what is in
Lordship,
my
I
mind.
understand.
Mr. T.J. Mahathir and Senior Counsel, assisted by Mr.
MS.
M.S. Alam, Counsel for the petitioner. To stop. For forest will be there, you are there, Mr. R.R. Gogoi, then standing counsel for the Forest Department, and 1 and 2.
Yes.
And government, you'll be there, and Mr. K. Gogoi, then additional senior government advocate appearing for respondent numbers
5 and 7.
5 and 7. Is Das here for? Is Das here with Mr. Naik?
Yes, Lordship. See,
Acha.
3,
okay.
4 and 5, 3, 4, 5 and
Next
6.
para. Mr. P. Naik, Leonard, standing counsel for the BTC, appearing for respondent numbers
3, 4 and 5, Lordship.
3, 4, and 5. Submits that
5,
he has
5 is
received
Deputy Commissioner.
telephonic instructions today that the respondent authorities are searching out for the order of settlement in connection with the sand gravel mahar in question. Next, but accordingly, as prayed for, this the matter tomorrow, give it tomorrow.
All the three same, my lord. Next,
Huh?
next two item, my lord.
Next two items.
Same, my lord, because
Oh,
my
okay.
lord, I am the highest bidder, 2 crores difference, my lord. They always try to, my lord, find out to the fault in my lord, highest bidder.
It is okay,
My lord, same, my lord.
we can't have grievance with that. 12 and 13, same.
Same.
2 o'clock.
Lordship, I'm appearing for 3, 4 and 6. Lordship,
3, 4, and 6.
not
Okay,
5.
okay.
Same response.
5 will be there.
5 DC is there.
Acha,
Committee.
5, Mr. Gogoi.
Oblige, sir.
Okay.
My lord.
Yes, Mr. Gogoi, we'll have to give a direction here for a time bound decision.
They can take the instruction and come back, in a short day.
Malone may give some time, we will instruction.
We'll fix it next week, but I may issue the notice in the meantime. Mr. E. Ganguly, and counsel for the petitioner, and Mr. K. Goel, and a government advocate, additional senior government advocate appearing for the
I'm for 3 and 4, Lordship,
respondent numbers 3,
and 4, Lordship.
3, and 4. 3 and 4.
So at this stage, perhaps 1 and 2 notice perhaps may not be required. Because under the circumstances, they are not entitled as such to even hearing.
Then you strike it out, because otherwise you'll have to give notice. I can't dispose it of without.
If they take the necessary instruction.
No, no,
then
no.
the Deputy Commissioner
Since I'm issuing a notice, notice has to go.
Lordship, they are not necessary because
No, they are not necessary, because of the fact that he's taken over the property under Sufficiency Act. He wants you to
under the
what you facilitate as per the act.
Lordship.
So 1 and 2 are otherwise not a necessary party, but it is your call.
Then they may be struck out. They may be struck out because,
Okay.
because the speedy disposal.
Uh, at the outset, the Land Council for the petitioner submits that as the as under the Sufficiency Act, it is the respondent number 3 and 4 to take an appropriate measure for securing the possession of the security asset, the respondent numbers 1 and 2, who are the defaulters, are not necessary parties. First, accordingly, as prayed for, the names of respondent numbers 1 and 2 are struck off without altering the seriatim of respondents. Next paragraph. Issue notice of motion returnable on, give a date after 10 days, 7 days or 10 days.
46.
Requisite extra copies of the writ petition be served on the learned additional senior government advocate in course of the day. Next para. What is that provision for taking
Section 14.
Under section 14
14,
of
sir.
36, Lordship.
Exactly, sir.
as the petitioner has invoked the provisions of section 14 of the Sufficiency Act, seeking assistance of the district administration in taking over possession of the secured assets. It is provided that the pendency of this writ petition shall not be a bar
Lordship.
for the respondent numbers 3 and 4 to take and appropriate steps in accordance with section 14 of the Surface Act. Next, by the learned. The petitioner shall produce a certified copy of this order before the respondent numbers 3 and 4 to bring the order to the notice of the said authorities. Next, in the meantime, the learned additional senior government advocate may also obtain instructions list on so and so.
Keep it possible.
16.
You had allotted the house to someone, you had
Yes,
let out.
Living here since 1980.
But somewhere I found that you have let out the house to someone.
No, not that out, he is my relative, my. Football earlier,
But no, but once you part position, you are not entitled to retain position.
no, I have applied for allotment of the said flat in favor of me in Annexure 1 in the year 2015, my.
No, it can't be because there's
Well,
something
now
I
they-
couldn't follow it, I couldn't follow this when I am reading it. You see, how does this question of somebody else occupying the property has come up?
Because of that, I have applied.
Oh, okay. Now, one more question before I begin. Has the petitioner filed any other writ petition in this court?
This petition on me.
No.
Earlier, occupier Utpal Suikia filed an writ petition.
Huh?
Utpal Suikia filed an writ petition. In
He
2008.
filed a writ petition. Now, where is that?
That is disposed of,
Where is the order in that?
because not annexed.
No, because you see, I distinctly remember having dealt with this matter. In that proceedings, I have dealt with the matter and therefore I am recollecting it.
In that order also, my lord,
It was about 3 years back, but I still retain that memory. Because that was a unique case. But get that, you have the number of the writ petition?
yes, my lord,
What is that?
yes, my lord,
You have a number of the writ petition?
no, my lord. Yeah, I have the number in the annexure, my lord, 4, my lord,
Annexure 4.
page 25. 4279. Public 18.
Okay, Mr. Das, just try to get this order, final disposal order, WPC 4279 of 2018.
Yes.
After some time, let my court master get this order. After some time.
May please your lordship. And in this case, petitioners are in possession.
But we can't do anything. This is a case, you see, Mr. Gogoi, the petitioner is 46 years now. Application was made by his father in 86. That means he was either born or not even born.
Yes.
Number one. Second is that your death of your father is not there. You
Yes,
just
it
say
is
he
there.
died long back.
It is there.
No, you did not get, you have said that he died long back.
No, my lord.
Where is it?
Grandfather died long back, my lord. Petitioner father in 2007, my lord.
No, grandfather is who applied.
Father, my lord. Father of the petitioner.
So we need the date of death of your father, not your grandfather.
Yes, my lord. That is 27/1/2007.
Where is that?
Page
Paragraph
paragraph 2,
two, Lord.
my lord.
Paragraph
Paragraph 2, lords.
2.
Page 8, my lord. And listen.
27/1/2007.
Yes,
So you see, 86 to 2007
Yes.
is how many years? 20 years.
yes.
So
Nothing
your
was
father
done.
abandoned this for 20 years, and now you have come up after 20 plus 13.
70 years, my lord.
No. 2007 and now it is 23,
30 years.
16 years. So for
My lord,
36,
this On several occasions, my lord, petition was submitted, my
no,
lord.
it is amounts to abandonment after 36 years of application, you can't expect the court to issue a notice.
Lord, kindly see page 37, my lord, on 5/5/22, they.
You see, this Deputy Commissioner's office, Mr. Chauhan,
Yes, sir.
is not a court of record. They will not keep your record of 1986.
My lord, they are scheduled caste persons, my lord. Provision is there, my lord, in my land policy of
And
1989.
does it say that for 30 years you can keep it pending?
But they have done nothing, my lord, my respondents.
For 30 years you abandon it. Once you have abandoned, why would the court come to your aid?
They are still in position, my lord.
No, you remain in position, but that, what
They
you
are
call,
paying land revenue also, my lord. Kindly see, my lord, page.
you see, we can't give a direction to the respondents to take action on the application filed in 1986. We'll open a floodgate.
Thereafter, my lord, also they filed a petition on several documents, my lord. On 5/5/2022.
Where is that?
Page 37, my lord.
37.
Yes, 37. And lastly, on page 49, my lord, on 6/1/23.
Even lordship in 1986 representation lordship, it says that lordship, he had not any possession by cultivating land lordship. Otherwise, lordship, he has a land lordship regarding residential lordship. Regarding land policy lordship, the landless peoples are getting lordship.
They are landless people, my lord. They have no land.
He have said that
established, my lord.
I do not have any periodic portal land for cultivation lordship. In page 35.
It doesn't say, doesn't have land for staying.
lordship.
6 bigger land we can't be given to you.
He never says that he has not any residential plot of land, otherwise only says that there is no any land regarding cultivation lordship. In 1986 representation lordship.
My lord, at that point of time, my lord, there is a specific provision in land policy, my lord, for the scheduled caste person, my lord.
Nowhere it is there that for 30 years or 40 years you can sit idle, and then also court would issue a notice.
But settlement, my lord, in case of settlement, my lord, that should be considered.
After 30 years, 30, 40 years,
Well,
I am not issuing.
In 2000,
Everybody can get it, you see, everybody can come up. There will be a queue in the court.
land policy of
Somebody has
2019
applied,
also,
you see, somebody has applied 40 years back. Why should we consider it now?
my lord,
You did not apply.
yes,
you
my lord, kindly see page 49, my lord. On 6/1/2023, my lord.
49.
Yes, my lord. 49, NXRE. Right for taking of protection as regards to implement roofing and elements to villages and prayer is well there.
You see, Mr. Chauhan,
Yes, my lord.
the court is not impressed because of one more reason. You see, an application for settlement of land.
Yes.
Is it an inheritable property? Your
No, my
father
lord,
died, so therefore I inherit that application.
it is not there, my lord.
So you will have to apply in your own name that you have not done. You are relying on a representation of a dead person.
My lord, kindly see the land policy of 2019. 1.7, my lord. As far as practicable preference shall be given in the matter of allotment of government land for ordinary cultivation in the rural areas.
This is not a rural area.
In
Your police station is Mangalday. If it is a police station in southern Mangalday, it will not be a
indigenous
rural land.
landless cultivator, kindly see, my lord, indigenous landless cultivators preference will be given to the landless indigenous cultivators belonging to scheduled tribes.
In the middle of Mangalday, you are doing cultivation. In the middle of Mangalday, you are doing cultivation.
My lord, I am cultivating.
We'll ask him to get instructions. You get instructions whether it is a cultivable land, and you also produce photographs of the land, present status. Not more than 2 or 3 pictures. We want to see the entire land. Having noted, Mr. R.S. Chauhan, the counsel for the petitioner, and Mr. K. Goel, and government advocate, additional senior government advocate appearing for. You are all the respondents?
Lordship, I am for 2, 3, 4, and 5. lordship.
2, 3, 4, and 5, and Ms. P.R. Mahathir, and the counsel for government advocate for respondent number 1. Next para. Having noted that the petitioner claims that his father had applied for land settlement on 5/1/1986 for the purpose of cultivation. Which is in respect of land measuring 6 bigha covered by DAG number 833 of village so from page 51 data schedule is there 51 page 51 so and so. Actually, I'll give it my village Upahupara UPAHUPARA comma Moza Rangamati RANGAMATI comma Mangalde Revenue Circle. Comma the petitioner is directed to produce of at least 2 or 3 photographs by which the court can understand the nature of land. And in the meantime, the additional senior government advocate shall also obtain the status of shall obtain the information regarding the as to whether the land is a cultivable land, is under cultivation. Next, the learned additional senior government advocate shall send a downloaded copy of this order to the concerned respondents to obtain instructions. This one next Wednesday we are fixing.
Say. For 7 days, next week.
Then Friday 19th.
Lordship.
19th, sorry. No.
9/6.
9th.
9/6.
Okay, 9/6.
Lordship.
List in the motion column in 9/6.
In the meantime, my lord,
No, I'm not protecting. Oh, just this item 16. You see this. We'll take it up after some time. At 2 o'clock, we'll take it up. You just go through it. And you take collect information as to what you call policy of allotment of flat by this urban housing development.
In the same building, my lord, the housing board allotted the rented owner flat, my lord.
No, it's okay. Since I don't know that policy,
Yes.
I can't jump into conclusions. It is just incidentally that I remember this case because of the same issue, rented property. I just remembered it. I don't know why. At 2 o'clock, let him get, just try to read and understand because this Biplab Mahator name appears here. And he says that he is one is both are relatives and they are staying together. That is the background fact.
53 and 54. 53 and 54.
This is the Assam University matter.
Wait, is your lordship, I am appearing on behalf of Mr. S.P. Chaudhary for respondent number 2 in item number 53. Lordship. We have not received any instruction yet, Lordship.
No, you will not get it, and you, let the petitioner come, we'll take it up after some time.
55. 55. 55.
Now the prison call, password for the day.
We have 53 and 54, maybe taken after some time. My senior is on the way.
We have already password, okay. 55 adjourned. And so just
56.
This instruction was sought for.
yes.
In this
From
matter,
respondent number one
we have already communicated, my lord, 7 days more time may be required, my lord.
7 days more time. So I issue a notice then, because otherwise it is in a motion column. Mr. A. Paul and the counsel for the petitioner. And Mr. M. Chedial and government advocate appearing for the respondents. Next para. In this writ petition filed under Article 226 of the Constitution of India, the case projected by the petitioner is that he has been sentenced to life imprisonment by virtue of judgment and order dated 2011-2017, passed by the learned sessions judge Karbianglong, Difu, in sessions case number 56
1988 old.
of 1988 within bracket old, corresponding to sessions case number 303 of 2017 within bracket new. First of it is projected that the petitioner is now 77 years of age and is suffering from some kidney ailment as diagnosed in the Guwahati Medical College and Hospital. And therefore he is, full stop, therefore, comma, the petitioner has preferred a mercy petition before the Governor of Assam under Article 161 of the Constitution of India, read with section 432 oblique 433 oblique 433 capital A CRPC. Next paragraph. Pursuant to order dated 26/5/2023, the learned government advocate has submitted that the concerned respondents are seeking about a week's time to provide updated instructions. Next paragraph. In view of the nature of prayer made in this writ petition, issue notice of motion returnable in 2 weeks. Requisite extra copies of the writ petition be served on the learned government advocate in course of the day. List on after 2 weeks clear date.
16.
16/6. 57.
Yes,
Well, petitioner before your lordship, my lord, is agreed, my lord, of a retender, my lord.
yes, yes.
By the chief engineer, my
Can you
lord.
deposit 20 lakh rupees in course of the day today?
20 lakhs security, my lord.
By the end of today's banking hours, can you deposit? How much is the tender money? Deposit, what much is the security deposit?
My lord, it is a amount of rupees 4 crore 60 lakhs.
4 crore 60 lakh. So 4 crore 60 lakh, can you deposit in course of the day today?
In the course of the day, my lord, it is not. Over, my lord, I will have to instruct any. My
Then we are
lord,
dismissing your writ petition.
my lord, kindly see, my lord, here, my lord, earlier, my lord, this package, my lord.
First round of writ petition, you can't pay. Second round of writ petition, you can't pay. Third round of writ petition, you can't pay.
My lord, no, my lord. Third round of petition, my lord, the honorable court had reacted to consider my representation, my lord.
Correct?
My lord, but they did not consider, my lord.
Will not, so now we are considering, can you pay it today?
My lord,
If you can't pay security, we can't postpone.
additional performance security, মানে I will pay money. If additional performance security, that was claim money. Additional performance security, that was claim money. And
No, you see, the Supreme Court has directed. Now you are in the mercy of the court.
my lord,
You see, the Supreme Court says that you have to give adequate security.
my lord.
So we can demand adequate, anything, any security. Your estimated cost is 41 crore.
My lord.
We can also direct you to deposit 51 crore rupees as security.
My lord, no, my lord, they had, my lord, required the,
You can't,
Additional performance security,
you can't take on ransom.
my lord,
the state.
additional performance security they demanded, my lord. That was challenged only, my lord.
You're
Only
not
that
impressed.
one, my lord.
No, you're not impressed. We are dismissing your petition.
My lord, can we take it tomorrow, my lord? In the meanwhile, I will be offering instruction, my lord.
For PWD, who's there? Will be appearing for PWD,
My lord, Gogoi was appearing.
Mr. Gogoi.
The governor.
Just wait for some time. There's some PWD people can be here. Wait for some time.
Problem.
SCPWD.
Your lordship. The requisition against the arbitrary and unconscious decision of the government.
Who's there for fishery? Fishery, who will appearing? You will be appearing?
The government fishery. Government fishery, government can also appear here, government fishery.
You want the second file? Mr. Gogoi, we were requiring your presence. In the previous item, item 57,
Yes, sir. Yes, sir. I will be appearing, my lord. I was on late.
yes, we are fixing the matter
Yes.
tomorrow.
Sir. In fact, my lord, there are certain judgments, my lord, orders, my lord, which have not been annexed in the present petition. I have
No, that's
got the
why,
entire
that's
bunch.
why we
There
are
is
calling
some
you. We are not
submission,
passing in order without
Okay.
your information. Who's for the petitioner?
57.
Both sides are represented. On the prayer made by Learned Counsel for the petitioner, just give it tomorrow.
I'm obliged.
Tomorrow or day after tomorrow? Friday then. But we see you on Friday. Not tomorrow.
Obliged.
The question is that the additional, the security would be 4 crores some odd rupees.
Yes, my lord, it has been already done. Thereafter, my lord, another writ petition was filed which is
No,
pending.
I have seen that. So
They approach the
security is
division
how
bench.
much? For 4 crores 60.
Lordship,
4 crores 60.
lordship.
That is to be deposited with you.
Yes, it was to be deposited. He did not deposit. Thereafter, my lord, he approached his honorable court.
No, that sequence I am aware.
Yes.
So amount, I am only asking the amount. Amount is 4 crores 60.
Yes, sir.
So
Then the additional security.
he's to take an instruction and bring us tomorrow whether in course of we'll take up the matter on day after tomorrow. By that day, whether he will deposit for
No,
6
my lord.
crore.
Here, my lord, that part has already been rejected
Acha.
by way of a speaking order. That has been suppressed in the writ petition and
Oh, acha.
challenging that, my lord, the speaking order, another writ petition is pending. In that, my lord, writ petition, the interim order was not granted by the honorable court. The petitioner approached the division bench. Division bench refused, my lord. Thereafter, he withdrew the writ appeal. These are the recent developments, not been mentioned in the writ petition, my lord.
Okay, then I'll
Suppressed.
record it. Then I'll record it. Mr. as counsel for the petitioner. Mr. B. Govil and standing counsel for the PWD
My lord.
has submitted that there is suppression of material facts in this writ petition because in the meanwhile, the petitioner has filed another writ petition
Lordship.
I had annexed that order, man.
and pursuant to the orders passed in the said writ petition, the petitioner had approached the division bench of this court by filing a writ appeal,
Yes, sir.
and the writ appeal was not entertained.
Not entertained, but he withdrew it, my lord.
And therefore the petitioner withdrew it,
Yes,
and that fact has been suppressed.
Yes. as well as the speaking order, my lord.
Oh, sorry, it is also submitted that in the meanwhile, the prayer made by the petitioner
Yes.
has been rejected by a speaking order. And that order is also suppressed from is suppressed in this writ petition. Next, with the resignation of the prayer made by Honorable Counsel to the petitioner. This in the motion column 1. Friday.
Obliged.
I am appearing for 5 and 7, my lord.
5 and
4 and 5.
4 and 5, Mr. AK. AK Datta, Counsel to the petitioner. 4 and 5. Yes, in item 58, since I don't know the this fishery law
Yes.
or the rules, you see, if there are two tenderers, you can't accept a tender.
My lord, I have to take instruction, my lord, clear this letter, my lord.
Because the rejection
Yes,
is on the
all
ground that
this-
there are only two successful
successful,
bidders, and therefore it can't be
successful, yeah.
accepted.
Yes, my lord.
At 2 o'clock, get that instructions. Because I did not find anywhere
Yes,
that if the tenders are only two, then you can't accept.
yes.
At 2 o'clock, try to get the information.
Further, your lordship, in the impugn order, the respondent number 2 has stated, it seems to be.
But
It is not-
Language I am not there,
But it's
that
not
much
a-
I don't read.
That annexa is the, my lord, internal communication, my lord.
Because
Whether
I-
all
if
the-
I-
Let them obtain instruction, your
Yeah,
lordship.
my lord.
Number one, I don't have that much of time. Number two, if I read that much, then maybe I'll be prejudiced and will not hear you properly.
Yes, yes, your lordship.
Correct. So I don't get that.
Until then, your lordship, they will not go for.
Not 2 o'clock.
Or 2 o'clock.
Huh. Till then, there is no interim order till.
No. 59.
Yes, item 59,
May it please, your lordship.
technical bid rejected.
Lord, the matter relates to a tender issued by the ONGC. For
Will be
basically
appearing for
exploration.
ONGC, does not have a council here.
No, they don't have a standing council, my lord.
Okay.
What they do, either they file caveat or based from
Okay.
case to case, they engage Mr. Mr. Sahela,
Okay,
senior
okay.
advocate, and Mr. Annexing. We
Oh,
wanted to
अच्छा.
serve copy. They
But
said, my lord,
okay,
we
okay,
don't,
okay.
can't accept.
Okay.
Yes. My lord, will kindly come to page number 119, just not a very big facts, small facts.
Because I could not follow that, you
It
are
is
saying
on the
that it
very
is
narrow compass, my lord, what had happened.
technical rejection, you say is
No,
illegal.
yes, yes, it was rejected. Now, my lord, if your lordship kindly comes to page
119.
number 291,
291.
291.
Because with this volume, I did not have courage to open it.
No, my lord, because the
No, it's okay, but I'm
big
just,
document is bulky, that's why tender matters are always very bulky, my lord.
it dissuaded me to open it.
Page 291, my lord.
And then I saw your name, I think that you would guide me better, so
Serial number 6, my lord.
6, yes.
It is a Mohabala Operations Private Limited. My lord, it's a good news. That's a local firm from Assam, my lord. Now they are on to exploration work. In fact, they have
Oh, there
already.
was one.
Huh.
There was one.
Yeah, no, my lord. In fact, this firm has also got a work in
His
ONGC
name
in
I forgot.
Assam Basin.
He was Burak Gohai or
Jane Borgohan.
Borgohai, yes.
It is some cases for. In between, there was none. All of a sudden, my lord, this party has emerged. Very good. Good news
He came from Singapore to settle here and do
Yes,
this
yes,
business.
yes. Because of the Chinese competition, he had to, he came to me in connection with 2-3 cases.
No, I was impressed with the gentleman
Yes,
because
yes.
man from here doing exploration work even in
in,
foreign countries,
Yes, other countries.
that impressed me.
Yes.
And,
If it now lordship kindly comes to 292, my lord, the reason is given.
Mr. Chaudhary,
Yes,
I'm just asking you,
Ah.
insofar as this case is concerned,
yes.
can I issue a notice, including notice in the prayer for interim relief and give a short date?
No, my lord, they will otherwise go ahead. My lord, it's a very
That's
good case. I'll just
okay.
take 5 minutes time, my lord.
Mhm.
Yes.
Page 291, serial number 6,
Six.
Mohabela Operative,
Hmm.
disqualified. Now at page 292, my lord, they indicate the reason. Page 292. Bidder is not meeting financial capability criteria as per BEC. Bid is commercially not acceptable. Am I clear, my lord?
Yes,
Yes. Now, my lord will kindly come to page number 315. My lord, lordship knows there is a concept of independent monitors, my lord, where you can appeal.
there also it was rejected.
Uh-huh.
Your contention was
No,
rejected.
yes, page 315, my lord. That discloses the reason actually.
3,
Page 315.
315.
Yes. My lord, there are two requirements. One, I need to have a turnover, other is my net worth. Now, on the ground of net worth, my lord, my tender was rejected. 9.1. ONGC informed that as per the tender requirement, net worth shall be based on the latest audited financial statement. Tender was opened on 11/11/22. Therefore, audited financial statement of financial year 2021-22 will be latest one. Since as per tender condition, the financial year closing the date of immediate previous year's audited consolidated annual financial statement should not be older than 18 months from the bid closing date. As per the latest audited financial statement of financial year 21-22, net worth calculated by ONGC and as indicated by Mohabela in their offer is lower than the required as per the value of as per tender. Therefore, offer of the bidder does not meet. What they say, my lord, that my net worth as per 2021, I do not meet. Therefore, my lord, my tender is rejected. This is the ground. Now, my lord will kindly come to page number 34 for a moment, my lord, for a particular date. Page number 34. This is the tender, my lord. This is the government portal, my lord. Only for the purpose of date, I am drawing your lordship's attention on top. 29/22. Am I clear, my lord? 29/22 on top right hand side.
Yes.
Yes. Now, my lord will kindly come to page number 122.
Just on. Page.
Page 122. Criteria for ascertaining financial capability of the bidder.
Yes.
All the below mentioned applicable financial criteria shall be met by the bidders as applicable for procurement of the service contract. Turnover of the bidder equal to more than 44.57 crore. Net worth of the bidder equal to or more than 13.37 crore. Am I clear, my lord? There are two aspects, one turnover, other is net worth.
Yes.
Net worth of the bidder for the current financial year, it should be 13.37. Now, my lord will kindly come to subpara 4.
Yes.
For ascertaining the turnover criteria of the bidder, if audited consolidated annual financial statement of 2021 is required to be considered, average turnover of the bidder for 2 financial years having highest turnover out of the previous 3 consecutive years shall be considered for meeting the requirements of turnover. That means, my lord, ideally, my lord, since the tender was issued on September 22, therefore the latest would be 21-22. Now, my lord, if it is not there, then financial statement of the 2 out of last 3 years should do if it is more than 44 crores. So, my lord, in this case, there is no dispute with turnover. We have. Now, my lord, next. In case the bidder has
Just a
submitted.
moment, just a moment. For ascertaining the turnover of category, if audited consolidated financial statement of funds is required to be considered, average turnover bidder for 2 financial years having highest turnover out of previous 3 shall be considered for meeting the requirement of turnover.
Yes.
Okay.
So, my lord, there is no dispute with turnover. Dispute is with regard to net worth. Now, this is the catch, my lord. In case bidder has submitted latest audited consolidated annual financial statement of 2021 and is not able to meet the required net worth criteria, then their offer shall also be considered, mildly say also be considered, provided net worth as per latest audited consolidated financial statement of 2021 is positive. Supposing now, my lord, just to show my lord, please come to 142, my lord. I'll again come here, page 142. This is my position, my lord, page 142. Kindly see, my lord, 21, 22, 45.96 crore. That is my turnover. So I meet that 44, my lord. So there is no dispute. Net worth 21, 22, 13.18. My lord, we have what is required is 13.37. So, my lord, for 21, 22, I don't meet. Am I clear, my lord? The requirement is 13.37. I got 13.18. Now, please come to 122 for a moment, my lord. In case the bidder has submitted latest audited consolidated annual financial statement of financial year 2021 and is not able to meet the required net worth criteria, then their offer shall also be considered, provided net worth as per the latest audited consolidated annual financial statement is positive. My lord, if I don't meet, my lord, 13.37, then I can go to the last figure, and there, my lord, the only requirement is it should be positive. Now mine is positive because, my lord, 2021 was a COVID period. I have 10.57. It's still a net worth. It is not a negative worth. I mean, my lord, worth. Am I clear, my lord? Now, what the reason is given at page 316, lordship will see that proviso is not considered. Please come to 315, my lord. My lord, admittedly for 21, 22, my worth is not 13.37 as is required. It is 13.18. But the proviso says in that case also my case will be considered, provided for the last year my net worth is positive. So by though it is 10.57, but it is still positive. Therefore, they are bound to consider it. Now, what the decision-making process is faulted at page 315, my lord. This proviso was not considered. 315, my lord. My lord, after that 18 months, the sentence starting with, as per latest audited financial statement of 21-22, net worth calculated by ONGC and indicated by Mohapela in their offer is lower than the required value as per the tender. That is correct, my lord. Beyond that, there is a proviso. Proviso says, in case for 2021, my lord, if it is positive, then it will do that aspect is not dealt with. That's why, my lord, the decision-making process vitiates. In other words, my lord, my tender has been improperly rejected. They could not have, I mean, held my techno-commercial bid to be non-responsive. It clearly says, my lord, therefore, offer of the bidder does not meet the net worth parameter.
Okay.
They did not took note of that, my lord, proviso. I'm just reading it once again, my lord, at page
It's okay,
122.
That's okay.
Yes.
Mr. K. N. Chaudhary, General Senior Counsel, assisted by Mr. A. Sharma. Mr. K. N. Chaudhary, Senior Counsel, assisted by Mr. A. Sharma, General Counsel for the petitioner. Issue notice of motion returnable in 3 weeks.
No, financial bid to move. Well, I'm just indicating one thing, my lord. I'll brainstorm, my lord, not opening of the financial bid for the moment, my lord.
No,
Because
they
under
will
the
proceed,
portal,
but they will not finalize.
no, my lord, there is one problem, my lord. In computerized system, what happens, my lord, I'll be lost. Now they will go on, the computer will do everything, my lord. So this stay order doesn't fit. Therefore, they will not open the financial bid for the present.
Okay.
Let them appear and say, make their case, my lord.
Returnable in 3 weeks. Give a date after 3 weeks. Returnable on so and so.
19/6.
The petitioner shall take steps within 2 days for service of notice on the respondents by registered post with AD, as well as by email. Full stop. Prior to the next date of listing, comma, the proof of service of notice by email shall be filed by way of an affidavit. Next para, the learned senior counsel for the petitioner has prayed for interim relief. Next para, this, by filing this writ petition, the Article 226 of the Constitution of India, comma, the petitioner has assailed the decision-making process in technically rejecting the tender of the petitioner. Petitioner's techno-commercial bid on the ground that it has failed to meet the net worth requirement. Stop. It would be relevant to quote clause 6.2, sorry, 6.0. Bracket page 122. Next paragraph. It is submitted that the financial turnover and the turnover and net worth of the petitioner is as follows. This is page 142. Box. Stop. It is submitted that the reasons for disqualification as downloaded from the website discloses that on 29/4/2023, the bid of the petitioner was rejected while technical evaluation in the process of technical evaluation with following comment, inverted commas, bidder is not meeting financial capability criteria as per DEC, full stop. Bid is commercially not acceptable. Full stop. It is submitted that the petitioner had approached the what is it called? IEM?
Independent external monitor. IEM.
Independent external monitor. And the said authority by a communication dated, email communication dated 19/5/2023 made the following observations. Page 315. Next, accordingly, comment is submitted that while the authorities in the ONGC had rejected the techno-commercial bid on the ground that the offer of the petitioner did not meet the network parameter of the financial criteria, but the clause 6.0 whereby it is provided that in case the petitioner did not meet the net worth criteria, or then also their offer, also their offer was liable to be considered, provided that net worth as per latest audited consolidated annual financial statement of financial year 2021-2022 was positive.
2021, my lord.
No, that is if.
If, yes.
Now this will be read as 2021-22. And they said proviso was not considered. Full stop. In view of the aforesaid demonstration by the learned senior counsel for the petitioner, the court is inclined, as an interim measure, the court is inclined to provide that till the next returnable date, the financial bid of the.
My lord, will kindly mention the bid number at page 34, my lord.
Acha, financial bid.
ZEM
respect of-
22, on top, my lord, ZEM
Acha, in respect of bid number, capital GEM, oblique 2022, oblique capital B, oblique 2542603, dated 20.
and my lord will also indicate the
9,
item category,
2022.
my lord. I
Huh?
think item category,
Where is that?
but the serial number one, same page, my lord. Custom bid for services, hiring of services, that's
Yeah, acha, in respect of item,
category.
item category, inverted commas, custom bid for services dash hiring of services for 3D seismic SEISMIC data acquisition in all are capital, huh? NMONHP 20201 Narmada area for FS 202223. This will find it page 34. Next paragraph. Liberty is granted to the respondents to apply for modification of the order if so advised.
Deep level.
The petitioner shall produce a certified copy of the order before the respondent to bring it to their notice. List on so and so. We'll take a break and come back.
Fine.
Young candidate, I participate, I remember the highest.
He
four
failed,
times-
my lord. Only 30 days left, my lord, for this year.
No, but my lord,
Oh, acha. Is it?
yes, my lord, tender notice says, my lord, I'm coming. Tender notice says within 7 days of obtaining settlement, my lord, you have to execute an agreement in a specific stamp paper, my lord, and that has to be submitted in the office within 7 days. Then, my lord, you have to pay the annual fees money 7th of every month, my lord. If you default in consecutively 2 months, my lord, your tender will be cancelled without notice. Clearly written in the my lord tender notice, page 26. The settlement order.
26.
No,
Department
sorry,
is aware,
page
my
26, my lord.
Hello.
There is one page 26. There is one, 13. From the my lord, line 13 from the top. You by executing an agreement, the settlement was given on 31/12/2022, my lord. You by executing an agreement in a specific stamp paper and get it
Yes, we'll have to
registered.
take a decision in terms of this.
Yes, my lord.
We'll have to issue a notice. We can't.
Notice, my lord, if notice matter will be extra influx was my lord. Page 34, my lord, where
No,
submitted
no, you see,
representation.
I can't do anything. I am
Yes,
the
yes.
settling authority. It will be the respondents who will take a decision.
Yeah, respondent will take a decision, my lord. That he's a
But that's
respond
what I'm
number,
doing, what else I am doing. That is
Respond
what I'm
number-
doing.
respond number 3, my lord. If you can direct that to dispose of writ petitions, take a decision in this regard. That will, my lord, sufficient, my lord.
That's what I'm doing.
Yes, my lord.
But I am not disposing of any repetition ex parte. Without issuing a notice, I am not disposing at the motion stage.
Yes, ma'am.
But Mr. FKR Ahmed and counsel for the petitioner And Mr. S. Datta Lanet, standing counsel for the you're for all the respondents?
Oh, no, my lord. 1, 2, 3, and 5.
uh, Panchayat Department appearing for respondent numbers 1 to 5.
1, 2, 3, and 5.
So 1, 2, 3, and 5. Okay. Issue notice of motion returnable in 2 weeks. You are making.
Fine.
2 weeks.
Sir, can you fix a date, my lord?
Requisite extra copies of the writ petition be served on the learned departmental counsel for the appearing for the respondent numbers 1, 2, 3, and 5. Next, the petitioner shall take steps for service of notice on the respondent numbers 4 and 6 by registered post with AD. And in addition, notice will be served on the respondent number 4 by way of the by routing the process to the registry of the court. Next, the learned counsel for the petitioner has submitted that the petitioner was a unsuccessful tender in respect of which
Tangni opened weekly cattle market. It will also find a tender notice. Page 15, my lord.
Tangni,
Tangni cattle market.
TANGNI weekly cattle market. First off, it is submitted that the petitioner had submitted a representation. Where is that representation?
Page 34, my lord.
34, representation dated 20/2/2023 before the
Respondent number 3. Chief Executive Officer. And my
Before
lord,
the,
respondent number 4.
Chief Executive Officer, Darang Zilla Parishad, within bracket respondent number 3. We're projecting that the respondent number 6 was the successful bidder, had not deposited the monthly kist money for the month of which months?
My lord only paid, my lord, not a single. They have to pay 4,95,000 every month. Till today, they need to, in this for 6 months, 24 lakhs. Till they paid only 3,50,000.
Out of the how many kists have gone? Out of how many kists this amount is there? How many kists has become due?
For 6 months.
That out of 6 monthly kists. 6 monthly kists, comma, amounting to rupees
24 lakhs. My lord, 24 lakhs, 57,375.
75. Only a sum of rupees
3,50,000.
3,50,000 has been deposited. And accordingly, it is submitted that as per the tender conditions, as well as the order of settlement, comma, the respondent number 6 has become a defaulter. And therefore, the settlement was liable to be cancelled without notice. First off, we said we have the projection, comma, the respondent number 3 is directed to examine the complaint of the petitioner dated 20 February 2023 within bracket Annexure D and pass appropriate orders with instructions to their Learned Standing Counsel. List after 2 weeks.
We
The
do
petitioner
ask
shall produce,
permission, my lord.
the
I want
petitioner
to
shall
point it out.
produce a certified copy of the order before the respondent number 3 Yes.
With lordship's permission, my lord, I want to point it out one thing more. my
Yes,
lord.
yes.
Is page number 13 is the prayer portion, my lord. Prayer is to only cancel the settlement of the private respondent, not to resettle with him, my lord.
No, no, I'm not saying my settlement in my favor.
Only his grievances against the private respondent, not to give settlement to him, my lord.
No, correct. What is wrong in that?
No,
Yes,
no,
yes,
no, I'm not saying settle in
He's
my
not
favor.
seeking relief for himself. If he is, if he can satisfy, it will be retendered.
my lord. Otherwise also we are preparing for
You,
retendering,
you'll,
not
you'll,
retendering.
you'll get a
Fresh tender.
opportunity of higher revenue.
The fresh
Well,
tender has,
well.
fresh tender has already been circulated.
You,
In the month
you should in fact, ask your officers to guideline him.
My lord. Otherwise, department knows, my lord, how to recover
But they
the.
don't know,
Yes, yes, my
they don't know, otherwise they would have done.
lord. Obligement,
Because of some conflict in interest, they are not doing it.
my lord. Obligement.
Or rather, we should direct the inquiry to be made by the, what you call, by the, finance department.
Well,
Why your officers did not do?
my lord. I'll take the instruction, my lord.
No, I think we should give an instructions.
Well.
We should take care of the state fund. We'll direct the finance department to make an inquiry. Why revenue loss is tolerated by respondent number 3? And take departmental action if required.
We're not losing revenue, my lord.
Why?
Because, my lord, the revenue, my lord, the private respondents. bid
No.
is
You
much
see,
higher.
your tender condition is that within 7 days, if they don't deposit,
Right.
it will be cancelled. So you don't do it.
That I have to take instruction on that regard, my lord. Whether
Otherwise,
deposited-
Mr. Ahmed has other business also. He will not come here.
My lord,
Correct.
My lord,
Once
no.
you have not done it, it means financial irregularity.
my lord.
If it is financial irregularity, why should we not direct an inquiry to be made?
Lordship is very much correct, my lord.
Not only
The
this
next
one,
day,
not only this.
You tell them, otherwise on the
My
next day,
lord.
if nothing is
Not
done.
only this,
My lord.
this market, all the markets, you will find same thing, all the markets.
Obliged.
Item 60. Yes, Mr. Pataland, you will not, Mr. Sidia, you don't evict him without due process of law. It's a Pataland.
My lord, he claims, my lord, that it is a patta land, my lord. And the periodic patta is now the verification on the last occasion, my lord. I submitted copy of the notification, my lord. There's a periodic patta is on verification. The
You do it, but unless
No,
it is.
petitioner,
it is
my
there-
lord, now before that, my lord, as the, there is a contemplation of eviction on 3rd and 4th, my lord. And to take the precaution, my lord, petitioner may visit the office of the Deputy Secretary Revenue and submit his periodic patta to him, my lord, so that no untoward incident happens on 3rd and 4th.
No, we'll
my lord.
protect him from the orders of the court. We'll protect him.
Fine.
He is to go before the deputy commissioner within what time?
No, Deputy Secretary, my lord,
Deputy
Revenue
Secretary.
Department,
Uh-huh.
tomorrow, my lord, at any time, my lord, at 2 p.m.
Okay,
So that, that we can also take note of that, my lord.
okay. For Mr. M. Biswas and counsel for the petitioner.
And eviction only from the government, and not from the periodic. patta
That's why
land.
we are
That is
protecting him.
my instruction is also there, my lord.
And Mr. J. Chitial and standing counsel for the Caribbean Autonomous Council, appearing for respondent numbers 2 to 5,
2 to
7, and
2,
8.
3, 4, 5,
2
and
to 5, 7 and 8.
7 and 8.
2 to 5, 7 and 8.
6,
And
9,
Mr.
and 10.
K. Gogol and an additional senior government advocate appearing for respondent number
6, 9, and 10 lordship.
6, 9 and 10. And Ms. G. Hazarika and standing counsel for Revenue Department appearing for respondent number 1.
Eviction of,
Issue notice of motion returnable in 4 weeks. Requisite extra copies of the writ petition be served on the next state and departmental council in course of the day. Next, heard the Learned Counsel, heard also on the prayer for interim relief. Next, the petition is projected. The Learned Counsel for the petitioner has referred to page 43 and 34 of the writ petition to project that the petitioner is in occupation of two plots of land being Schedule A and Schedule B land, for which the petitioner has has been issued a patta being no, not 43. What is that?
For schedule A, my lord, the patta number is,
No, which page?
page number, your lordship will find at page number 23.
What 23, not 43, it is 23. Huh? Being periodic Raj Patta number 379. Of Moza, of village Lahorijan.
Lahorijan non-K,
Non-K.
page 25.
Don't make a typing mistake. Non-K. NON-K. Of Borjan number of Moza Borjan MBORJAN number 1. And periodic Raj Patta number 223 of village Lahorijan LAHORIJAN non-K Moza Borjan number 1. And that the petitioner is apprehending his eviction without following due process of law, for which reference is made to the order dated 20. Page 44 is the impugn order.
My lord, 26.5.
Order under number KMJ-175 of the prohibitory order of the 2061 of the 63 dated 26/5/2023. This is page 44. Issued by the district magistrate Karbi Anglong Difu.
This is a prohibited order under 144, my lord.
Huh?
This is the order.
No, that's why he's apprehending only that.
Oh, my lord. Oh.
He's only apprehending from that only. Because here it says that in the ongoing eviction drive, more than 5 people will not assemble.
My lord.
So that is why is the apprehension. First of next, the learned in this regard, the learned standing counsel for the Karbi Anglong Autonomous Council has submitted that as per his instructions, the eviction drive will only be carried out on the government land and not on the patta land. It is also submitted that in the meanwhile, the authorities in the revenue department of the Karbi Anglong Autonomous Council are carrying out verification process of the patta land,
Periodic patta land
periodic patta land
of village Lahorijan.
of village Lahorijan number 1. And accordingly, he submits that the petitioner may approach the Secretary Revenue,
Deputy Secretary Revenue.
Deputy Secretary Revenue, Karbi Anglong Autonomous Council, and produce a copy of the patta held by the petitioner, so as to enable the authorities to conduct their inquiry. First of all, in view of the discussions above, the court is of the considered opinion that as an interim measure until the next returnable date, the respondents in the Karbi Anglong Autonomous Council shall not evict the petitioner, namely Vishwajit Sharma, from the patta land referred herein before, without following the process of law. Next paragraph. However, the petitioner shall produce a certified copy of this order before the Deputy Secretary Revenue or Secretary Revenue.
Secretary Revenue. Secretary Revenue.
Okay, Secretary Revenue Department, Kazim Autonomous Council, within bracket respond number 4. Along with two copy of the self-certified copy of the Patta. Before the said authority to enable them to make inquiry. Next list after 4 weeks.
My lord, somewhere your lordship has noted Lahorijan block number 1. It has to be block number 3.
Okay, then make corrections. Otherwise, we'll not be able to get instructions. Correct. It will be 3.
Block number 3. Not
Make corrections. Otherwise, it will be difficult.
Auto block number 3.
Is 25 is the periodic Khiras Patta. That is, it is in Assamese, my lord. Lahore is a non-K Moja version 1 number. Khiras periodic Patta number 379. There is no, my lord, like that way. 3. Version number 1, my lord. Is 25.
It's 25. It is version number 1.
Egg number.
Page 13. No, it will catch up at you'll not.
So if another number is put, it will be difficult again.
So let it be my lord number 1 because we'll furnish a copy of this Patta. I have the original also. We'll furnish it. Let them verify. My lord.
Number 1, not 3. No.
1 and 2.
I'm deeply obliged.
Yes.
So, my lord, the national highway, my lord, they are constructing a highway, my lord, which passes through our land, my lord. And now, my lord, there is no notification, my lord. We know that our land is going to the highway, my lord, but the forest department is claiming that it is their land. That is the problem, my lord. So, my lord, we are praying that.
But what is this page 215? It appears that there is a order, at least there is a notification.
Yes, my lord.
Then-
Notification is there, my lord. But my lord, the forest department, my lord, they are claiming that this is their land. my lord. That's why, my lord, there has to be a demarcation, my lord.
No, for demarcation,
And my lord, the
No,
ARO
no.
report, my lord, page 224, my lord.
just a moment. No, because that's why you made me read this. You see, in page 25, there is no prayer for the demarcation. What you are asking is to disburse appropriate compensation. That is the only prayer you are having.
In the first read petition, it is there, my lord.
No, I don't know you. I see. I'll take it one by one. I don't remember all the files. If you are expecting that from me, I must congratulate you.
My
If
lord,
that is your expectation, because I read only the file which is before me.
at first we filed, my lord, 5812, my lord.
It's okay, but so far as one is concerned, what is your prayer? You see, for disbursement of compensation. Yes, disbursement of compensation, it will be by the deputy commissioner. By you.
This is my lord, national highway, my lord. So the central government appointed my lord joint secretary revenue as competent authority for land acquisition under the National Highway Act.
So he will disburse.
Will disburse, my
Huh.
lord. And then NSR is a deposit the amount before the Kala, my lord, competent, there is the joint secretary revenue, and we are disbursing the amount.
Okay.
And in this particular case, my lord, the earlier petition 2022, is item number 2. He, on that case, his prayer that he should not be evicted from the forest land. And that this is the, this 2023 case, 768 2003, he praised that compensation amount to paid to him.
Oh,
So he has, my lord, two contradictory stand, my lord, in both the read petitions. So both the read petitions are taken together, my lord, on our prayer, my lord. In that, if 5812-2022, his prayer is that he should not be evicted from the forest department, and forest department should not enter his land. That is his prayer. And in this particular prayer, he prays that he should get the compensation. And my instruction is that I have the map earlier occasion, I produced it before the court also, my lord, that it is the reserve forest land, my lord. And in the reserve forest land, my lord, so there is no acquisition of the, so the forest department is producing the apportionment compensation, my lord. And the NSFDCL will pay the compensation for or my lord, afforestation, my lord. That is the point, my lord. And if you require, we will file the affidavit to that extent also, my lord. There is no point on that. We will annexing all those documents also, my lord, that that my lord.
Just a moment. Yes,
Let them file the affidavit because they are saying it's forest land, my lord. We are saying it's our land. We have the pattas, my lord. And we have also the report, my lord, from the ARO office, my lord, which says that this is our land, my lord.
no, you see, if you are wanting compensation,
He should make the national NSIDCL as a party respondent. NSIDCL is acquiring authority, my lord. He has not made them a party also, my lord, in the petition.
Impeachment application filed.
It's wrongly implementing NHA.
NSAI, he included NSAI, National Highway Authority of India. But the project is implemented by the NSIDCL, National Highway, and Standing Council is also there here. And he has not implemented them as a party also in the petition.
okay, so we'll now direct them,
My lord, to implement them at first, my lord, so
Okay,
they can also
just-
say.
okay, just one by one. Just hear the order. If I am wrong, please correct me. In this item one. Heard Mr. F. Khanlan, counsel for the petitioner. Petitioners. Also heard Mr. J. Sutyal, standing counsel for the Karbi Anglong Autonomous Council. Appearing for
2, 3, and 7.
respondent numbers 2, 3, and 7. Mr. C. Barwal and
NHA.
just this one. So far as government, right? Mr. Hazarika, you are appearing for? Ms. G. Hazarika, standing counsel for Revenue Department and Revenue and Disaster Management Department. Appears for respondent number 1. Mr. K. Govind, an additional senior government advocate. Appears for respondent number 6. Next para, Mr. C. Barwal, and standing counsel for respondent number 4 and 5. Has submitted that as per his instructions, the National Highway project, in respect of which the petitioner has approached this court, is being carried out by National, what is the full name?
National
National Highway Infrastructure Development Corporation
Limited.
Limited,
Limited,
NSIDCL.
within bracket NHIDCL, who will be the necessary party in this repetition and not the respondent numbers 4 and 5. As they are not the implementing authority. First of the petitioner shall, learn counsel of the petitioner shall take note of the said submissions and take appropriate steps as he may be so advised. Post of. On the next date, the court may consider the pair of the learned standing counsel for respondent number 4 and 5 for deletion of their names. Next para. The learned standing counsel for the Karbi Anglong Autonomous Council has submitted that the NHIDCL has deposited the land acquisition compensation before the Karbi Anglong Autonomous Council.
Reporter, my lord, he's not. Reporter,
Karbi Anglong Autonomous Council.
no, my lord, he's the joint, he's not made them. Respond number 3, oh no, or 3, my lord. Competent authority, National Highway Authority on India North. my
Acha,
lord.
for the respond number 3, okay, respond number 3.
National,
I,
that should be deleted.
the competent authority, comma, National Highway Authority of India,
No, my lord.
oh, this will be
You're
wrong.
making that wrong, my lord, again wrong. The competent authority for land acquisition comes Joint Secretary Department of Revenue. He should, my lord, correct it, my lord, properly, my lord, otherwise.
They will not know these people. Just write one more line there before that. The London Study Council for the Carving Autonomous Council has submitted that the nomenclature of respond number 3 is incorrect.
Incorrect, my lord.
And as per his information, the appropriate authority would be the competent authority,
For
comma,
land acquisition
for land acquisition,
comes Joint Secretary Department of Revenue. Kabi Anglong Autonomous Council. He is appointed by the central government under section 3, small a of the National Highway Act.
okay, who has been appointed under section 3 within
Small
bracket
a of
small
the
a
National Highway Act
of the National Highways Act.
by the central government.
For all these two sentences, you write that the London Council of the petitioner shall take appropriate steps together. It is submitted that the compensation amount has been deposited with the competent authority of the Carbi Anglong Autonomous Council, and it could be dispersed on verification. Full stop. However, comma, it is submitted that in the connected writ petition, IWPC 5812 of 2022, comma, the main prayer of the petitioner is to restrain the forest department from entering into the land which is the subject matter of this writ petition. Full stop. Next, in the said connection, the Learned Standing Council for the Carbi Anglong Autonomous Council has submitted that he has the topographical map of the area where the land of the petitioner is situated, and as per his instructions, comma, the land falls under the reserve forest of Carbi Anglong Autonomous Council. Next, under such circumstances, comma, the Carbi Anglong Autonomous Council shall file their affidavit in opposition positively within 3 weeks.
4 weeks.
Make it 3 weeks, because other we will now then approach the vacations. It will be difficult to manage the code then. 3 weeks. List accordingly.
That reported he should correct it, my lord, otherwise
Ah,
it
he'll
is
do it.
difficult to, my lord, file the affidavit on behalf of respond number 3.
Okay, do it. In the meantime. You are right. You're right. Now in second case, you write
In the notice was issued, my lord, we will file the affidavit that was in the second petition,
in item 1, notice was not issued.
not issued.
Achha, notice. Revisit extra copies within 2 days from the correction of the cost title, which shall be done in the presence of registrar within bracket judicial, and simultaneously the copy of the writ petition available with the respondent, the Learned Council for the respondent shall also be corrected. In item 2, you write
Let's look into order dated 7/9/2022. I think notice was issued. Item number 2,
okay.
order dated 7/9/2022.
Here you write, also as a duly represented. With care of the submissions earlier of wrong parties. In respect of respondent number 3, three, 10, and 11. That will be repeated, huh? And NHAI and respondent number 3. I said the respondent number 3, he is now corrected in this cost title here, page 12, serial number 12. We will delete
That has not been given to us. Oh, my lord. I am expired.
It's not corrected in your copy.
My lord.
Okay.
12, no, my lord, here is also under National Highway Authority of India. That word is not required, my lord. That is another authority may be there. Competent authority for land acquisition, that word may be
Okay.
deleted.
Then,
by the
then
presence of it.
for both the National Highway Authority and competent authority, they are here, respondent numbers 10, 11 and 12. Repeat that. And this is the Land Council, Land Standing Council for the KAC, case for is granted 3 weeks time to file affidavit in opposition to the matter.
My lord,
You are there
if
Yes, Your Lordship.
for
1, 2 and 4. For the second item.
1, 2 and 4.
Forest one.
Who are 1, 2 and 4? Okay, environment. Your name?
M. Kalita, Your Lordship. M. Kalita.
And Ms. M. Kalita, standing counsel for respondent numbers 1,
2 and 4.
2 and 4.
and my lord,
Okay.
my lord, if NHA edition is implemented, I may take copy. He may give copy to me also because I am telling him exactly if he is implemented.
You take note of this submission.
Right.
53 and 54. We have filed the affidavit yesterday also. I think.
Affidavit, I am not aware if it has come. You have filed?
Your Lordship, we have filed it.
Okay. Yes.
I'm sorry, Lordship. I'm appearing for respondent number 2, Lordship. I have just received one communication from the respondent authority whereby pursuant.
Take your breath, take your breath, take a minute. Don't rush. Okay, closure is withdrawn.
Temple.
That we have not been communicated, Lordship.
It has been passed today itself,
It's
Lordship.
in past now. She went out. You were not there. She went out
I'm sorry, Lordship.
and got this. Correct. You don't be sorry, be happy that you were not there. Otherwise, the matter would have been adjourned. Correct. And she deserves a thank for coming running.
Certainly.
Correct. Okay. So you have made all of us happy, right?
Lordship.
Only next time be in time.
Yes,
Don't
Lordship.
rush.
I'm extremely sorry for
No,
that.
it's okay. We are not angry with you. We are not expressing a displeasure.
Yes.
Otherwise, I would not ask him to thank you, right? It is not an expression of displeasure.
Lordship.
Correct. Mr. A. Bhattacharya, Land Counsel for the petitioner, has submitted that he has filed an affidavit today.
Yesterday, Lordship.
Affidavit on 30/5/2023, which is not on record. Next para, Miss
Miss B. Devi on behalf of Mr. S.P. Chaudhary
B. Devi, Learned Counsel appearing on behalf of Mr. S.P. Chaudhary,
for respondent number 2.
counsel for the respondent number 2, has produced a copy of notice dated 31/5/2023, whereby pursuant to order passed by this court in WBC 2651 of 2023, the closure notice issued on 20/4/2023 was temporarily withdrawn. Full stop. Next para. A copy of the said communication has been provided to Learned Counsel for the petitioner. Next para, as the issue relating to students, student boarders in
NIT, Lordship.
NIT Silchar is the subject matter of this writ petition. List the matter on. After a week, give a date.
14/6.
14/6/2023. In the meanwhile, you'll file your response.
Yes, yes, Lordship.
In the meanwhile, the respondents shall file their affidavit in opposition.
If I may make
Okay.
a submission before lordship. If it has been temporarily withdrawn, then petitioner may be allowed to continue lordship. If they have given it to somebody else, petitioner is not being allowed.
I'm
That
not
is-
saying anything.
That is my instruction.
I'm not saying anything.
Lordship.
Lordship, I am appearing on behalf of SCKL respondent one.
Acha, your name
Age,
on behalf of Mr. SC Cal, standing counsel for respondent number 1. Okay.
So far, the other writ petition is concerned, Lordship wanted to have a look into the representation of the deputy commissioner, whereby the deputy commissioner, whereby we have intimated the deputy commissioner that we will not be in a position to make any supply to the bungalow. Lordship, that is in annexation number 17, page 85. We cannot arrange the party on 12/2/23 at DC Bungalow, as we are totally out of cash and suggested other caterers name as they worked earlier as well. This is what triggered the dispute.
But then the deputy commissioner is not wrong. If you're out of cash, how will you give service to the?
Lordship, for a long time,
hostelers.
we have kept pending.
No, but that is okay.
And we
But
have
you
been
see, you are a
only-
contractor, no, Mr.
we have been
Bhattacharya
only
ji.
serving the government contracts only.
No, that is okay. But if you don't have cash, how will you carry on catering? Then your
But-
termination
but
by
the-
the,
but the
by the
impute
NIT
order-
was right.
But the impute order says different.
No, no, that is okay. But if you
Impute order
admit,
says that the quality is not good, the disease order.
no, definitely, you see, if you don't have cash, this issue came up yesterday also.
Now
In
it's-
in a different case.
This operates
it-
as a vice versa. The Lordship will kindly appreciate that.
No,
if
I
the
understand,
bill-
you see, but you see, the difficulty is that we are dealing with students, number one.
Absolutely. This is not.
It's a
student.
hostel, then
This
the
is not
question
student,
is,
Lordship. This is DC.
no, that is, this is different.
This is different.
But you see, if you don't have cash for deputy commissioner, you don't have cash for anything.
It's
Correct?
not like that. That is being operated in a different manner. It's regularly operating. This is, we said categorically for that Bungalow party, 12/2/23.
Okay. But Mr. Gogoi, he raises a very serious question. This is a serious question. He's showing that page 85,
Yes,
show it to him,
the second petition,
second petition.
second writ petition, annexure 17, page 85.
Before it is also,
Page 85.
second it is also.
Just give your copy, just give your copy.
Lordship.
Mr. Gogoi, this deputy commissioner was having a party at his house. He wanted the petitioner to give catering there. He refused that he will not give. Correct. And now because of that, the
Lordship,
deputy
this-
commissioner writes to the
it-
NIT to cancel his contract.
I remember this, Lordship. He's also filed a writ petition. Lordship, regarding Lordship, we have already blacklisted him, Lordship. Not only that ground, regarding food qualities and others thing, Lordship.
That was in the.
No,
appeal
that is
note.
okay, but
Lordship.
Genesis is this,
Yes,
Lordship.
Genesis is. this.
correct? Because,
Lordship.
because Mr. Gogoi,
Lordship.
you see, we both go to the same party,
Lordship.
correct?
Lordship.
I find that in the food,
Lordship.
salt is high. You say that you find it okay. Third party said it was fantastic. So in the same party, 10 people will be there, they have all different moods,
Lordship. Lordship.
correct?
Lordship.
So somebody likes the food, somebody doesn't like the food. But for that, food quality for someone to say,
Lordship.
he must be having some qualification, because you see, I know tea tasting.
Lordship.
There are qualified tea testers
Lordship. Lordship.
who will say that. Now, who will certify that this food quality is good or bad? The tiffin I bring in my table, is very ordinary. Correct. Absolutely ordinary, but I like it.
Lordship.
In the best of the food, I dislike and I prefer my own food,
Lordship.
even if it is very ordinary quality. So it depends on person to person.
Person to person,
Quality
very
of food. You
very-
must have some description somewhere.
Lordship.
But this, you see, let us assume
Lordship.
that the deputy commissioner did not like the food.
Lordship.
But can he recommend to others to blacklist him?
No, they cannot, Lordship.
It cannot be.
But otherwise, Lordship, this particular petitioner, Lordship, I remember one petition is preferred by the petitioner, Lordship. That district administration already blacklisted him, Lordship.
No, it's
regarding-
okay.
Lordship,
But you see,
Lordship. Like, but we cannot interfere with the other institute.
the
or-
other institute, you can't do
we
it.
cannot, Lordship. We cannot, Lordship.
You take an instruction on that.
Lordship, Lordship.
Hmm.
It wasn't me. 54, I don't know.
In fact, in 54 already we have received the instruction that the instruction is very specific as regard that before blacklisting, he has been so caused. Thereafter, the food inspection has been done, and from the food inspection, the report has placed from which some anomalies has been found as regard to food safety. So accordingly, that has been communicated to him. His reply has come in. This was not found satisfactory. Finally, he has been blacklisted. So this is the procedure which has been adopted before blacklisting him. So in fact,
Show me the documents.
Now, if I may just.
So these things will have to be filed by our affidavit.
if you can-
Mr. Barwa, these things will be filed on affidavit.
Yes. Yes, we
If I
can.
may just submit one line in this regard.
It's okay, let them file an affidavit. Uh, That is the second lead petition.
Second,
Second, if in fact, Lordship, letter was communicated by myself, Lordship.
No, it's okay.
Lordship.
Also, it's a duly represented. Mr. S. Barwa, government advocate, appearing for respondent numbers.
Respondent number 1, 2, 3 and 4.
1, 2, 3, and 4. Place one is granted 3 weeks time to file affidavit in opposition to the matter. The next part, the case of the petitioner is that by the impugn order dated 13/4/2023, he has been blacklisted, right?
Lordship.
Full stop. As notice of motion was already issued on 3/5/2023, it is made clear that no. Three, taking note of the delay in filing of the affidavit in opposition by the respondents, it is provided that letter notice on the prayer for interim relief be also issued, which is also made returnable in 3 weeks. Full stop. Accordingly, provided that in the event the respondents do not file their affidavit in opposition, or the prayer for interim relief shall be considered on the next date.
Development.
I have to rise early today. Even in the second half, I'll be rising early. Yes,
Actually, item number 21 and 22 may be listed after mid of June, Lordship.
I have not received instruction, my lord.
Even they have not received instruction.
I have to
what is the matter? This is, I don't remember.
21 and
What is-
22.
what is the matter?
Regarding my lord,
Regarding cancellation of contract and then banning.
banning, my lord.
Oh, okay. When do you want?
Lordship, anytime, Lordship, 15th or 16th of June. Till then, instruction,
Lordship may fix it on a non-miscellaneous day, Lordship.
yes.
Non-miscellaneous day, I'm not fixing any matters. I have a lot of cup of tea pending.
Lordship,
Right.
any day, Lordship.
That's why I referred to tea testing. In the last matter, I have few cups of tea which I have yet to taste.
Lordship perhaps the experience with, perhaps helped by the Amal Das, his brother, elder brother. Kamal Das, Lordship.
Huh.
He was a tester initially.
Now I know that.
Yeah, Kamal Das was stated.
item number 50, my lord.
Full June.
This will take care of it because I have to rise.
After 2 weeks,
This
my
matters item number
21 and
21 and 22.
21 and
Lordship.
22, because we'll fix it on 14th then.
Lordship, 16th, Lordship. 16th.
16th.
Lordship.
Okay, 16th, make it. Other matters just tell me postmaster.
Much obliged.
In this case, the land is a railway land, right?
The petitioners are the owners of the landlordship. They,
No, but the
Land-
land was acquired for railways.
yes, yes.
Where is the entry in the Jamabandi for that? How can I identify which is a government land and which is your land?
Yes. In the Jamabandi, it should be reflected lordship.
You have given a copy of the map.
Yes.
It doesn't show anything. Which is the railway land, we don't know.
In additional affidavit lordship.
Shows that.
Yes. In additional affidavit lordship.
First of all, in the additional affidavit, in the index you have given wrongly shown a chitta. It is not chitta, it is
Yes,
a drawing of the land.
Yes, I have corrected it.
It's okay. But drawing of the land, I can't understand anything.
Yes. In the,
Because this is all black and white.
yes.
But I assume that in the middle in the triangle
Yes.
is the government land. Rail line of Jua Mati, Jua Jomi Sinno.
Yes, Lord.
So therefore, this is the railway land, which is that dark, which is that description we can't see from here.
Yes. Record was called for lordship.
You see, you are the writ petitioner. You must make it easier for me to understand. If I am saying so many things, that means I have read it,
Yes, yes.
correct?
Yes.
Otherwise, I would not have been able to pinpoint that document. So if you are producing a trace map which I can't read, what is the fun in reading that?
I have
And second thing is that,
I have original one lordship.
so which is the government land, which is your land, that you have not identified.
1046 is our land lordship.
10,
46. 1046. I have original one. It is.
you come to your Jamabandi 1046. This railway land is out of which dag?
Our dag number lordship 10.
No, I'm not interested in your dag. I'm trying to understand the railway land.
Yes.
The railway land is has been culled out of which dag? You have anything with you?
Lordships, in the interlocutory application, my lord, may kindly peruse page 9, my lord, annexure 1. Petitioner has annexed lordship 1 notice lordship under the public premises eviction and unauthorized occupant act lordship. It was issued by the state official lordship, railway lordship. This is the appealable, or this order is appealable lordship.
Is it
Under-
appealable?
Under section 9, statutory provision is there, Lordship. Statutory alternate remedy is there under section 9 of the Lordship, public premises eviction and unauthorized occupancy Act 1971, Lordship. Here is a notice regarding, Lordship, the unauthorized occupant. The ground is also given, Lordship, that the land in question is a railway land, that you are unauthorizedly occupying the land, that now railway requires the land for development work, Lordship. Hence, therefore, in pursuance to subsection 1 of section 4, Lordship,
Because you see, you are Mr. M.J. Gogoi. Mr. Gogoi will not be entitled to any interim relief. You see, come to your reply at page 13. Now in page 13, you see, you are saying in 2007, some portion of your land was taken away and the railways are not interested in paying compensation. So if that be so, if the acquisition has taken place, then there can't be any injunction. We can't restrain the railways from taking it. Now the entire case is that you want money.
Yes.
For money, you make a claim. You write to them for the compensation, you show them the documents and the deputy commissioner will pay. Did you go to the deputy commissioner? I didn't find anywhere that you have said that you have visited the deputy commissioner's office and this land was never acquired.
Direction may be given to.
Why should I give a direction?
even my lord, section 5 notice was also issued, Lordship. It is in page.
Why are you entitled to a direction? Your land has been acquired. You show the notification, go to the land acquisition branch and take that money.
You know, sometime given to us, Lordship, but matter may be kept pending. Maybe it may not.
So you see, you are making a prayer for upgradation, then you don't want to do it. So therefore you see, you know the procedure of land acquisition. If not, you'll have to visit the land acquisition branch and then learn how things are processed there in the deputy commissioner's office. Because if you can show that your land acquisition compensation, what you call the gazette, from there you will find the land acquisition case number. From that case number, they will be able to track out and trace and produce that record.
Yes.
You just have to go and sign and take your money.
Sometime may be given to us, Lordship, to
Okay.
verify that, Lordship.
No, it's your own case that it has been acquired. Verification, you can't say that you have made a statement without verifying facts. Because if you say that, your writ petition will be dismissed on that ground alone.
So it may be kept pending for the time.
Okay.
You may.
Mr. Gogoi, let him take instructions.
Lordship.
Interrogative application. Mr. M.J. Gogoi, learned counsel for the petitioner, and Mr. K. Gogoi, learned counsel for the applicant and opposite party. Opposite parties are present. Next para. From the contents of Annex 2 to this interlocutory application, it appears that the petitioners have admitted that the land was acquired in the year 2007. And the grievance expressed is to the effect that land acquisition compensation was not paid. Full stop. In that view of the matter, the learned counsel for the applicant, prays for and is granted time to obtain instructions. When do you want?
2 weeks.
List after 2 weeks is paid for. And that there is a question of this, if it's an appealable order, you also take instructions, otherwise your appeal will be barred by limitation deadline.
Lordship, even after issuance of the section 5 notice, Lordship, only 14 days is, Lordship.
It's okay, but
Lordship.
we'll just guide him if
Lordship.
you can take the. Correct.
Yes.
Take that, understand that, otherwise you will be in difficulty again.
Problem, Lordship.
Item number 5.
The petitioner had earlier approached Mr. Honorable Court, challenging the
Which is the, which is the impugn order?
Yes.
Which page?
Page number, my lord.
Page 108.
Yes.
That is your impugn order. You can only issue a notice at this stage.
Lord,
This will be subject to final orders which may be passed. Because we can't do anything more.
My lord, in the last occasion, my lord, the dishonorable court has some instruction regarding the jurisdiction of the issue, this ARCS, my lord, page number 108. Whether because the as per election rule, my lord, the appeal was filed before the registrar, and as per 2F, my lord, there was an
No, you see, your prayer is that that this election be set aside.
yes, my lord.
We can't do it in the interim stage.
At least, my lord, the board, my lord, that may functioning may be, my lord, the state, my lord. and
No,
the-
no, elected members, how can we stop it?
My lord.
Then what happens to the final relief?
My lord, there may be some officer management from the department, my lord.
No,
may-
no, no. Why?
May, my lord, because my
Why?
lord, the rule is violated, my lord, section 26(3), my lord. I have a copy of the honorable court order, my lord. May I supply, my lord, one copy of the order?
No, you see, that contention was raised by you,
Yes,
but that was rejected by the Assistant Registrar of Cooperative Societies,
yes, my lord.
correct?
The
So the,
order is, my lord, purely a mechanical order, my lord, without going to the inquiry as per rule of 27. What 27, my lord, may I read for a moment, my lord, it is mentioned in the order of that. For a moment.
no,
my
not
lord.
without notice to the other side.
For a moment, what the rule.
I
says-
can't stop performing performance of the board without hearing the other side.
That is right, my lord. For a moment, the earlier order of this honorable court, my lord, what is the direction, my lord? Writing the page number, page number 70, my lord. Relevant paragraph, may I read, my lord? Only one paragraph, my lord. Page number
Page?
74, my lord, the relevant paragraph.
74. Yes,
Yes, my lord. My lord, merit 14, my lord, the register of election authority may register or election before consideration of representation appeal so and so shall issue notice to all the stakeholders and the representation appeal thereafter be disposed of by speaking order after hearing all the stakeholders. In above view of the matter, the representation is not granted liberty stands reserved petitioner to approve the election authority in the aforesaid manner as the remaining 27 election rule is efficacious and adequate one. It is observed that the event of petitioners take recourse of 27 election rule, election authority shall decide the dispute by following observation made above, my lord. Now, what is the rule 7, my lord? I have to read, my lord.
that is not required because you see from the impugn order it appears, number one,
Yes, my lord.
that one person was disqualified because his PDS license was suspended for illegally selling government PDS rice and was imprisonment. He suffered imprisonment, correct?
Yes, my lord.
Second is that one Zakir Hussain Laskar, who is a muster roll worker under APDCL, his also remuneration was accepted. So you'll have to show that these people could have contested the election.
Yes.
Where is that?
My lord,
You see, it's a society. If a person who is imprisoned may not be qualified,
my lord, that was actually.
and that was accepted by the ARC.
My lord, that are the grounds taken after the election, my lord. But the petitioners approved this honorable court before election, my lord, challenging the.
It's okay. Is this mention of this persons who was arrested and who is in muster roll worker? Is it false statement?
Yes, my lord.
It's a false statement.
My lord, that it is from the allegation of the petitioners, my lord. It is right, my lord. They will produce the documents, my lord. But it is not properly, my lord, passed the order, my lord. As per rule 27, my lord, the election rule, there should be a proper inquiry, my lord. Proper inquiry
Without inquiry, how could the authority find that he is
Yes,
a
my
PDS license holder?
Yes, my lord. It is not properly passed, my lord. After
No, but
after
just tell
inquiry.
me, I'm just trying to think aloud. I'm trying to understand. If I don't make an inquiry, how do I come to a conclusion that the man was selling PDS lice? Number two, that he is a APDCL muster roll worker.
Yes.
How do I arrive at a finding without making a proper inquiry?
My lord, rule 27 says, my lord, that the
Uh,
election authority shall cause
cooperative
necessary
societies.
inquiry.
Ah.
My lord, for rule 27 the election rule.
Yes,
Yes, my lord, rule 27 says, my lord, the election authority shall cause necessary inquiry.
27
27.
of the Cooperative Societies Act,
No, my lord, for the election rule of 2019, my lord,
election rule of,
2019, my lord.
I don't have that. Yes, rule
Rule 27, my lord.
27.
Redressal of disputes. As per rule, any dispute relating to election of property may be submitted within 3 days from the date of election of the result before the election authority. The rule 21B has provided that the election authority shall make an inquiry
Yes,
on the disputes. So no inquiry is made, my lord, only on the basis of the statements of the my lord, persons concerned. It is disposed of. The my lord, if I read the impugn order, my lord, it will show, my lord, that how the order is passed in a mechanical manner. Only the perusal of the
no, just let me understand, Mr. Kabir. This rule 27,
Yes.
that upon inquiry.
Yes.
Now, is anywhere, anything is defined that how an inquiry should be conducted?
not my lord, not.
So manner of inquiry is not documented, right?
Yes.
It's not under the act and rules.
So my normally, my lord, some reports may be called, my lord, from the concerned authority. The short order, my lord, may I read the impugn order, my lord? There is nothing
Just-
mentioned
just a minute.
about
Just-
recording
no,
of any statement of the any
Just
witness.
a moment, just
Yes.
a moment. no. You see, I have read this so many times. Again, I'm still trying to read this and understand page 74 and 75, para 15.
Para 15.
What did this court say?
Yes, my lord.
He will pass order on the representation. Correct?
Yes, my lord.
So you agree to this? Pass an order on representation. So he is passing an order on the representation.
Well, as per 27, my lord.
It doesn't say so. You see, filed by the end of 27, but High Court says pass order on representation. So now you can't come up and say that the representation must be disposed of under 27.
Well, page 15, paragraph 15, my lord.
I'm reading that.
Yes, paragraph 15 of the appeal filed by the petitioners under rule 27
Oh, that is okay. But next, what does the court say?
of the election rule and functioning of such elected members of the board shall be abide by the decision of the election authority. So 27 says,
No, no, please read, please read. You're
Yes.
not yet complete.
having considered, my lord, 15, having considered.
It
all-
is expected that the election authority shall make endeavor to pass necessary order on the representation of the appeal to be filed by the petitioners as expeditiously as possible. That is all.
As per 27, it is not.
You move
passed.
this court and in appropriate jurisdiction to get it modified. That the hearing should be on as per 27.
Well, 15 says so, my lord. Paragraph 15, my lord.
I am reading 15 only.
Yes, my lord.
I am not reading something else.
Yes, my lord. Review will filed by the petitioner under 27, rule 27.
That's okay. Please don't stop there. The paragraph doesn't end there.
The election rule 19 and the functioning of such elected members of the board of directors of the society shall abide by the decision of the election authority so passed. It is expected that the election authority
Shall make endeavor to pass order
on
on the representation
appeal appeal, my lord.
Public appeal, yes.
Yes, at 20 as
So he's
per-
done, he has passed on an appeal, where it says that you make an inquiry. So if you want that inquiry to be made,
my lord, 27, my lord.
if you are not satisfied with the nature of order of the High Court, you have to ask for modification. Because now the authority has passed an order on representation.
My lord, Rule 27 says, my lord, after inquiry, the order should be passed.
The court is aware of it.
Yes, my lord.
The court was aware of it when when the court is writing section 27.
Yes,
But it then says go and dispose of the representation. So
Yes.
representative appeal, whatever be,
yes, my lord.
has been disposed of. You can't complain now that the hearing as envisaged in 27 did not take place. That was never the idea of the court.
My lord, what is my understanding, my lord, if I am not wrong, my lord, this honorable court has rightly passed the order, my lord, that the appeal should be filed under 27 within 3 days of the result of the election, my lord. And that should be
No,
disposed.
we always, you see, the court is always conscious,
Yes,
the passing an order, very consciously passing an order. In this case, give an opportunity of hearing to the parties.
yes.
In some cases, we consciously write, dispose of the representation. And in passing on order of dispose of the representation, the question of hearing and national justice, the opportunity of hearing will never arise. Unless you can show me otherwise, you can show me any other authority on the point that, well, disposal of representation means compliance of national justice also. And if you can show that, this, I'll be,
My lord,
what you call,
my lord,
I'll be too happy.
yes, my lord, on Monday,
Not on Monday,
Wednesday,
Wednesday.
public. Public.
The Mr. Anjay Kadir, the counsel for the petitioner, has raised a grievance that the Assistant Registrar of Cooperative Societies, Silchar, had passed an order on his appeal. Passed the order dated 13/4/2023 on his appeal without compliance of the provisions of Rule 27
Seven.
of the
Assam Cooperative Election Rule.
Assam Cooperative Societies after societies apostrophe election rules, 2019. Full stop. On a next paragraph 15 of the order dated 25/1/2023 passed by this court in WBC 395 of 2023 is extracted below. Full stop. It appears that the operative direction of this court was to dispose of the representation of the appeal to be filed by the petitioners. Post of the said order does not envisage the said order, in the considered this said order, prima facie does not disclose that any opportunity of hearing was to be granted to the parties. Next, per under such circumstances, we will the learned counsel for the petitioner, based on granted time to make a submission on the set point. Next, is wait for list on 7/6. 7/6/2023. Okay.
All right.
Yes. So we send you back then to the,
No, because to 435, as per what your lordship has seen, because earlier the 452 was not there. Then the amendment came, so either it should go back, I think that will be better. Go back to the, because otherwise also, except 452, which is being stated. So 452, they will decide whether they are entitled or not, that is only. Should it go back to the original court in Dibrugarh? That is the only issue that I am actually raising. Because 413
Yes.
initially did not bring in 450,
Uh,
435, sorry, 2013 Act.
I was thinking that I would have time to read.
No, I
452.
I have given the copy.
No, it's okay, but
I'll just read that for a moment, 1 minute.
but I really could not look into it.
I understand. The 2000, initially 2013 Act, 435,
No,
One.
your submissions I've understood, but
Yes.
just to
Yes.
confirm, because you see, Mr. Manan, the difficulty is not understanding you. The difficulty is that if I give a wrong order, I can't vest jurisdiction on the court which doesn't have.
yes, exactly.
That is the
that
anxiety.
is exactly the
Yeah.
reason, your lordship, I have just pointed it out.
Understanding you is not difficult. You have made it very lucidly clear. No point in not.
Just Lordship will
understanding.
read the 435 of 2018 Act and the subsequent amendment. Only
That's
these
fine.
two, your lordship, the difference that has created the problem.
Except under 452. Yeah, right, we'll send it back. But there is again a difficulty.
Lordship.
I think this formal corrections we'll have to do. I had taken the view of the registry. In fact, in the meantime.
With regard
This
to-
227 will have to be
226.
226. You.
So we have to convert that to two.
No, I'll give a direction, but it will come Monday or Wednesday, I think. It will come on Wednesday. Monday and Tuesday, I'm tied up.
No problem.
226, I'll give a direction that will be done by the registry.
If it is.
So please pursue it
Yes, yes,
with the registrar judicial. You're right. Having read to this, what you call 435,
Yes.
I think your interpretation has to be accepted.
Yes, that is what I.
Has to be accepted. The yeah. The court finds that as per the Guwahati High Court rules, the court does not have superintending jurisdiction in respect of trial by the special court. And this is under the Companies Act 2013. So therefore,
Under 227.
superintendent jurisdiction, I would understand. Superintendent jurisdiction. So therefore, Mr. Y.S. Manan, counsel for the petitioner, is permitted to make necessary correction in the cost title of this petition to insert Article 226 instead of Article and to substitute Article 227 by Article 226. The said correction shall be done in the presence of registrar within the judicial, and thereafter the matter be listed again in the. This is motion column. In the motion column on. It will be 7/6/2023.
That obviously, I have to correct it myself.
Yes.
So then at least on Friday then, because the file will go back to the register, they will call me. I don't know, it might not be.
No, we are fixing it on 7th. You have 4 days time.
Oh.
You have 4 clear days time.
7th is next.
No, the files will go to him. Don't worry about
No, no,
that.
I have no problem. If it is 7 next week, I'm just thinking this, sorry, sir.
No, because today is 31st.
Yes, I actually was thinking this week, that is why.
Oh, acha,
Next
acha.
week.
Okay. Okay, I get it. I get it. So intermittently, I'll be traveling.
In that case, just one clarification, I think I have to add the state as a part. That It comes to 26. Because if
Oh,
you give
acha,
with regard to the jurisdiction, then I have to make the general administration department. the part.
No, not general administration. Mr. Barua. The state will be a formal part. I think it will be judicial department.
Oh, yes, maybe.
Judicial department.
Judicial.
Huh.
Maybe come secretary judicial department.
Because offences under Companies Act was triable earlier by the special tribunal. Now with that amendment in the Companies Act, now it will go to the jurisdictional magistrate, not by a special tribunal. 452 has been excluded except 452. So appropriate party would be the state represented by judicial department, or what is the name? It's judicial department.
Judicial, that would be under lordship, the judicial. If that's so lordship, that would be under judiciary lordship.
Judiciary can't be made a party. We have protection under Judicial Officers Protection Act. Therefore, the state, if it is an Article 226 application, state who will be represented? Who will represent the state?
Judicial department lordship.
Judicial department,
It's a formal
Huh.
part, the judicial department.
because it has to go. It's only a formality that the state has to be made a party. Because the jurisdiction has been taken away, the act has been amended. So it has to go from the special tribunal to the jurisdictional magistrate.
Yes, yes.
But since it will be 226,
Yeah.
the state will be a formal party. So it will be judicial department. The state. The petitioner is also permitted to impede the state of Assam, represented by the Secretary, Judicial Department. By hand, under his signature, and provide a copy of the petition to the government advocate. List on 7th.
Much.
There's one more matter, lordship, item 60. I missed the matter actually, lordship.
Just a minute, we will finish this. This is okay?
Yes.
Please inquire, judicial, I forgot, judicial, it should be judicial department.
I'll ask the additional
Nomenclature.
advocate. Let me ask the additional advocate general. If it is something different, I'll come back.
Just tell the court master will write in the slip and give it to the court master, will correct it.
Right.
You don't have to address me. Yes, what is this item 60 you are referring to?
Yes, item 66, lordship, it was not called for, lordship.
No? I think I passed some orders. Achha, record his presence, it says CKS Barua. I said outside presence, I think. I said outside presence. Huh?
So I was defending railways in there, lordship, and I was also filed one affidavit.
Okay. Something has happened, I just missed the track. Once the file goes, I missed the track. Once the file goes, I miss the track. I won't remember. Unless I get the file back, I won't
I will
remember.
collect the next.
Yes.
Item 65.
Yes.
Yes, that is better.
Yes, we'll take it up.
Item 65. submit.
65.
Or some- Just a brief part of list of dates, notes, just.
Yes.
Only one judgment, my lord, I will refer, and then, my lord, if you worship, allow me today, my lord.
You want to refer to a judgment?
Only
Okay.
money that I have given to your worship, my lord.
Okay.
This note I have given last page of the note, my lord. The rest you have given, except number 5, my lord, last page. my lord.
Yes.
Only matter that 1986 TSC, my 156. That is the stronger and weaker between contact between two parties, my. Paragraph matter 89, 90, 93, that just yellow sequence. Eighty-eight, 89, man. I've given a copy, man. Page, you lost page 216, man. 215, 216. The just matter top after 4-5 lines I'm reading, my. That's should the strong, my second line, should the strong be permitted to push the weak to the wall? Should they be allowed to ride roughshod over the weak? Should the court sit back
Which,
and
which
watch?
paragraph? Which paragraph?
Paragraph 89. Right? First, 88 minus only very small paragraph minus page 88, paragraph 88. Right? After paragraph 88. Page 215. The worship got it.
Yes.
As seen above, from the judicial decision, the United States and the United Kingdom have statutorily recognized, at least in certain areas of the law of the context.
But just now, Mr. Chaudhary, sorry to disturb you, but I'll break your concentration. But you see, this Brajanath Ganguly case
Yes.
was that after the steam navigation company was wound up, there are three categories of what you call employees. One category, when the new management took over, there was an agreement that their what you call service can be terminated at any point of time.
51 notice.
So that condition was challenged.
That's too much. In this case, that is that the employees of that year.
Huh.
But only about they have just some principle they have decided. I am only on that mind. The exact fact is not my lord.
Huh.
Principle my lord, only my lord, in a contract or a clause in a contract. But I'm getting 88 third, fourth line. Clause of contract where there is inequality of bargaining power. There I am only my lord, I am coming. Inequality of bargaining power between the parties, although arising out of substance. That one. Then page 21 for next paragraph file. Next paragraph on page 216. I am only because the time when the agreement was entered, we are looking for the means of livelihood. You wanted to engage us, and you have come with some agreement, which is prescribed format, dotted one, my lord, format is there. We had no other option, my lord, we have to take it. And you have put the condition, we have accepted it. That is not disputed, my lord. We accepted it, my lord. But here the only paragraph 89, my lord, only matter that article 14 and article 39A also, my directive principle, that also decided by.
I don't know, because once you cite this Brajanath Ganguly, many questions will come up.
My lord, exactly that what I'm not.
No, you just come to para 91 last part.
Yes.
It's just for you. You may not read it loud.
Yeah,
You may not read it loud. It's just for your consumption.
yes.
Brajanath Ganguly. Now, last 6 lines. While the law of contracts.
Yes, in England.
Huh.
is
Only
most-
that much. You read yourself. You don't have to read it
Yes.
out.
The law from beginning days in filling state in England. In order to see. Much more than one of the elements. That is my law. That's a that's my that 23 was my avoidable. That is my law. I'm not on the.
No, I get your point.
Only by the
Get your point.
bargaining, what was my stand and what their stand, man. I had no other option.
But when it comes to Brajanath Ganguly,
Yeah,
I
that's
always
my
remember
was absolutely right. So this is my addition, my lord. Rest a note I have given, just small note, my lord. And my only prayer is, my lord, you have 5 days back, you have stated no decision to terminate.
It brought me back those memories of 23, 28 and all those sections.
So that's my, this is my.
I'm not taking an adverse against you, but
But
It's okay, I take the principle, sir. Okay.
and other cases are pending, matter where status is already there. That also your lordship mentioned, I think your lordship order also, my lord. Last order, my lord, you should notice, my lord.
Because when it comes to this specific relief act, I think it becomes a core issue, what you call.
That,
subject.
I am only on the part of gaining capacity where I stand, where they stand. So that was that they have said.
No, but mine tends to
Yes,
digress.
that your lordship.
Mine,
Yes,
mine,
right, my lord. Sorry.
it digresses
Yes,
from here to there.
that's fine. That's why, my lord, we also enjoy sometime here, man. So things come in there. That's your.
I can't be monotonous. I don't know why.
No, that should be there.
I-
Always it should be lively, man. That's
I can't be monotonous.
one should
can't
not
be.
be, man.
And there are only few people with whom I can share a smile. Otherwise, it's also difficult to
No, my lord.
smile and laugh at
Without
someone
difference,
nowadays.
we should not say that I know much more than that, sir.
No, not that, not that.
Should not say my.
No, not that. But you see,
Sometimes difficulty
now-
arises from that. my lord.
now the complex society is so complex that if you share a what you call lighter moment with someone, one may get offended. Things are not so easy as it was earlier.
That's.
When we were kids, things were different.
Things-
Things were different.
It all depends how we take it, man. This is the whole problem right now. So
Right, right.
that is
You're
the
right. You're right.
whole thing.
For a matured mind, it is no problem,
Yes.
but it is.
Not
for
to
immature
offend,
mind.
okay, man. I don't think that something should remain in my mind. I should not offend. That is where the problem arises.
No, unless I interact, I don't give you an opportunity, number one. And number two is that I may learn something in the process when you make an answer. But you see, and that is that under the scheme of the what you call this distribution policy, you are required to give it to the franchisee. You can't do it yourself. So why terminate A and appoint B? That you will have to address.
I'll come to that. I'll try and
It's
satisfy.
it's one of the most important
I'll satisfy my-
part of that argument of Mr. Chaudhary.
As the termination clause for a moment, my lords,
Huh.
at page 31.
31,
My lords
yes.
has item 65.
Yes, I'm 65. I don't know, but this 2916.
Yes, my lords, 2916, page 31. Clause 14, my lords, termination. Relevant being 14.2, my lords, the agreement can be terminated by either party by giving a notice of 1 month in advance, my lords. This is the clause that the APDCL has invoked. Now, the termination notice, my lords, is at page 43.
Forty-three.
43. So notice dated 2nd May 2023. May I read, my lords, the relevant portion?
What do you mean by AT and C? At page that for clause 14, 1.4. So clause 3, AT and C.
My lord, it's all technical and commercial losses, my lord. The
All technical and commercial loss.
commercial loss.
Okay.
I'll have
Technical,
to-
my lord,
I'll have to
cooking and
confirm this, my lords.
Okay.
Page 43, my lords.
Just a moment. I'll write it. Otherwise, I forget. Yes.
Page 43 is the termination notice, my lords. With reference to the above, this is for your favor of your information that so and so. Agreement dated, executed from this end on 1st December 2016 against 20 numbers of DTRs with a contract period of 2 years had expired on 1/12/2018. But you've been allowed to continue operation as per terms and conditions of the executed agreement by giving timely extensions, the latest extension being provided up to 30th April 2023. This is relevant, my lords. However, it is no longer commercially expedient for the APDCL to continue with your contractual obligations. And therefore, in terms of clause 14.2, termination clause of the CDPF agreement, it has been resolved to terminate the contract so executed with you with effect from 1st June 2023, my lords. Now, the expression here is, my lords, commercial expedient, no longer commercially expedient, my lords. I'll come to that, my lords. My first submission is with regard to the maintainability of the writ petition, my lords. My lords have raised a query under section 14 of the specific relief act, my lords. There is a specific bar when it comes to determinable contracts for enforcement of such contracts, my lords. Now, my lords, section 14 of the specific relief act. Contracts not specifically enforceable, my lords. The following contracts cannot be specifically enforced, namely 14D, my lords, contract which in its nature is determinable, my lords. Now, in this case, my lords,
Specifically, fact. Actually, that is good.
fourteen D, my lords.
Yes.
My lords, 14D. Contracts not specifically enforceable. The following contracts cannot be specifically enforced, namely clause D, my lords, subsection D, a contract which in its nature is determinable, my lords. Now, in this present case, my lords, there is a termination clause, and there is it is contingent upon an event happening, my lords. APDCL has issued them a notice as per clause 14.2, giving them a 30-day notice period, saying that we are terminating the agreement, my lords. Now, on this point of law, my lords, I'll like to rely on two judgments, my lords. The first judgment being Indian Oil Corporation Limited versus Amritsar Gas Services, my lord, 1991, 1 SCC 533. Para 2 deals with the facts of the case, my lord. They're identical to the present case, my lords. May I read para 2, my lords?
Yeah, first of all. Just a moment, I'm trying to see something. Yes.
Para two is with the facts of the case. My lords. There was a distributorship agreement executed between the IOCL and the Amritsar Gas Service. My lord, the clause 27 of the agreement provided for termination of the agreement by the corporation forthwith on the happening of a certain specified events. Clause 28 thereafter, my lords, permitted either party without prejudice to the foregoing provisions or anything to the contrary to terminate the agreement by giving a 30 days notice, my lords. Now, para 9, my lords, pertain to the arguments that were advanced in the matter, my lords. Placitum A, my lords, at page 541 is relevant in our present case. My lords. May I read, my lords?
9.
Para 9, my lords. Placitum A at page 541, my lords. The next contention.
Yes. Yes.
Malas Placitum A at page 541, Malas. The next contention is that the relief of restoration of the contract granted by the arbitrator is contrary to law, being against the express provision in section 14 and 16 of the Specific Relief Act. It is urged that the contract being admittedly revocable at the instance of either party in accordance with clause 28 of the agreement, the only relief which can be granted on the finding of breach of contract by the appellant corporation is damages for the notice period of 30 days and no more. Now, my lords, the finding the ratio is at para 11, my lords. Starts from para 11, my lords. It goes on at para 12.
Just a moment. Yes.
Let's para 12 is relevant, my lords. The bottom of para 12 at page 542, my lords. Subsection Placitum I, my lords. Subsection 1 of section 14 of the Specific Relief Act specifies the contracts which cannot be specifically enforced. One of which is a contract which in its nature is determinable. In the present case, it is not necessary to refer to the other clauses of the subsection 1 of section 14, which also may be attracted in the present case, since clause C clearly applies on the findings so and so. This being so, granting relief of restoration of the distributorship, even on the finding that the breach was committed by the appellant corporation, is contrary to the mandate of section 14 of the Specific Relief Act. And there is an error of law apparent on the face of the award, which is stated to be made according to the law governing cases. The grant of this relief in the award cannot therefore be sustained. Thus, following this very judgment, my lords, there is a judgment of our honorable court, my lords, honorable high court. I'm passing a copy of this. This is 2003 1 GLR 619, my lords. Star India Limited versus Urup Bora and others. Para 4, my lords. May I read, my lords?
Yes,
My lords, para 4. Mr. So-and-so, appearing for the appellant, assailing the order of the learned court, has placed below the relevant clauses of the contract agreement and contended that the instant contract, as evident from the opposite clauses, is determinable in nature. It is so determinable on the happening of events contemplated as well as on the volition of either of the parties by giving 30 days notice. The contract therefore cannot be specifically enforced in view of the bar under section 14(1)(c) of the Specific Relief Act. On next page, my lords, page 622. Reliance in this regard has been placed on the decision of the Apex Court in Indian Oil Corporation Limited versus Amritsar Gas Services and others. Now, my lord, the ratio is at para 6, my lord. May I read, my lords? Tacitum G, in the case of Indian Oil Corporation versus Amritsar Gas Services, the question was whether the arbitrator was right in ordering for the restoration of a distributorship after holding that the agreement, though determinable in nature, was not validly terminated under the relevant clauses of the contract agreement. The Apex Court in the case laid down that as the arbitrator had held the contract to be determinable in nature, even on finding that the contract was not determined in accordance with the clauses providing for such determination, the arbitrator would not be entitled to order for restoration of the status of the parties prior to termination in view of the specific bar contained in section 14(1)(c) of the Specific Relief Act. The remedy of the aggrieved party and the power of the court in the event the rescission of the contract is held and found to be contrary to the terms of the contract providing for such rescission is to seek grant damages by way of compensation. The rationale behind, this is important, the rationale behind the legislative bar to specific enforcement of a contract determinable in nature appears to be that the courts can never be understood to issue futile writs, my lords. An order of the court specifically enforcing a contract can be immediately set at naught by the parties by determining the same in accordance with the relevant clauses providing for such determination. This is the basis on which the legislative bar to specific performance of the contract determinable in nature appears to have been made.
Just 1 minute. Yes.
My next submission is, my lords, it is a dispute arising purely out of a contract, my lords. And my lords, this honorable court under 226 cannot go into a dispute for which a private law remedy is available, my lords, to the petitioner, my lords. In this regard, my lords, I'll place a reliance on a judgment, my lords. National Highways Authority of India versus Ganga Enterprises, my lords, 2003, 7 SCC 410, my lords. Para 6, my lords.
This, what you call National Highway,
My lords,
Ganga,
Ganga.
I think this will not be a,
There have been other judgments thereafter, my lords, on the same line.
no, you see, here, basically there was a contract where before the offer letter, it was withdrawn. That is the background facts of this case.
My lords. But However, my lord, the ratio perhaps might not be applicable. Para 6, because it relies on
Because
other judgments.
once it says there is a public law remedy available, that means the court is directing the persons to what you call claim compensation.
Compensation.
This will not apply here.
Para 6 for a moment, my lord, perhaps, my lord, because it places reliance on other judgments of the Honorable Supreme Court, my lord.
It's okay because you see, because of the fact that you see that will naturally follow because of the simple reason that it is only an expectation of a person to get it before he gets it and he is deprived. So at best, the public law remedy would be to have compensation. But that is not so in case of termination. Because then in case of termination, then it will be case of claiming a damages for wrongful wrongful termination, and for that the parameters are different. But still, let us see 6 what you are trying to say.
The 8th sentence here, my lord.
Hmm.
It is settled law that disputes relating to contracts cannot be agitated under Article 226 of the Constitution of India. It has been so held in the
Where you
cases.
are reading? So para 6,
Para 6, 8th sentence, my lord. 8th sentence. It is settled, my lord.
8 line.
8th line.
Okay.
It is settled law that disputes relating to contracts cannot be agitated under Article 226 of the Constitution of India. It has been so held in the case of Kerala so and so and state of so and so versus so and so. This is settled law. Right? That's what it says.
That is why no, I'll tell you why. I think the perception in which you and I am traveling are different. You see, in this case, that's what I was remembering. In this case, in the footnote 1, is a judgment 2000 volume 6 SCC 293. Footnote is last page.
Last page, yes.
End note, in fact, not footnote, it's an end note. 2000 volume 6 SCC 293. That is referred to, it is referred in paragraph 6 also. It is the Kerala SCB versus Korean E. Kalathil. Para 6, correct?
Yes, my lord.
Now, this is a case where this Kerala Electricity Board had given a contract of construction of a dam to this petitioner. And therefore, it was a dispute, purely dispute, contractual dispute. It is in that context, the court says under 226, you can't go into it because it requires some sort of evidence. But here, that's what I'm saying, the argument of Mr. Chaudhary is also dependent on on the principles of your policy. It says that this has to be given it to franchisee. Correct. So that the question is that you terminate one,
Subject
So
to
that-
correction, Malad, that is not the
Ah.
policy, Malad.
it's okay, but that's what I understood.
Malad.
So therefore, you see, we go back to the case of Pyara Singh and say that one cannot be substituted with another. One temporary cannot be substituted with another. Therefore, if that principle is accepted, then I cross the barrier of 14.
Yes, thank you.
And then you see, I can always see this with a different angle. Here, I'll just show you the provision. You have specific leave act with you?
Section 636, perhaps, Malad.
No, 34.
34.
I would travel to 34.
Status of the right.
34 says, any person entitled to any legal character or to any right as to any property may institute a suit against any person denying or interested to deny his title to such character. So you see, the right to do business is also akin to a right of property. Therefore, if if that argument is accepted, then perhaps we can also travel into the area of section 34 and say that it's a discretion of the court, but this is not a justiciable right. One can't assert that he has to be given this declaration. It's a discretion of the court. And that this is a discretion is well settled in various judgments of the Supreme Court. It's a discretionary relief. It's not a, what you call, right which can be demanded as a matter of right. But this is what is troubling me. Because if it doesn't,
I'll try and satisfy Malad on that issue. Now, Malad, my Lalit senior had placed reliance on certain sections contained in the Electricity Act, Malad. But Malad kindly has the Electricity Act 2003 for a moment. Section 2, Malad. Section 2, subsection 4.
appropriate commission.
Appropriate commission, Malad. Means the Central Electricity Regulatory Commission referred to in subsection 1, or the State Regulatory Commission, Malad, which in our case is the Assam Electricity Regulation Commission. As for the state of Assam. AERC, Malad. Now section.
Okay, just a moment. Let me first record your the citation you gave. 2003 7 SCC.
410.
410. Yes.
Section 2, subsection 4, Malad.
Yes.
Definition of appropriate commission, Malad. Means the Central Electricity CERC or the AERC in our case, Malad, the State Commission. Now, subsection 5, my lords, defines appropriate government. Subsection 5A, my lords, the central government in respect of a generating company, wholly or partly. I'm not reading this, my lords, it's not relevant. B, in any other case, the state government having jurisdiction under this act, my lords. Now, under section 2, subsection 17, my lords, defines a distribution licensee. Means a licensee authorized to operate and maintain a distribution system for supplying electricity to the consumer in his area of supply. Now, the APDCL, my lords, is a distribution licensee. My lord. Now, the learned senior had referred to section 5, my lords, which deals with the policy. May I read section 5 for a moment, my lords? Section 5 says national policy on electrification and local distribution in rural areas. The central government, my lords, the first line, please note, my lord, kindly note, my lord, the central government shall also formulate a national policy in consultation with the state government and the state commissions for rural electrification and for bulk purchase of power and management of local distribution in rural areas through panchayat institutions, users, associations, cooperative societies, NGOs, or franchisees. The mandate is not assigned to a distribution licensee like that of like the APDCL members.
I'm not unable to follow you. Please repeat again.
My lords, my lords kindly has section 2, subsection 4. My lords, it defines an appropriate commission.
Oh, just a moment. I think other matters I will not be able to take up. This will take some time, and I'll be rising at 4 o'clock.
I have one matter, your worship, that's for instruction, your featuring matter, 58, only instruction.
58. Okay, before rising, I'll take it up. Other matters I may not be able to take up because I'll rise at 4. I have to attend the Judicial Academy.
Number 16, 16.
Tell me the fourth master. After this matter, we'll take it up because I'm unable to hear you. If you have some urgency, you can wait for some time. After this finishes, because at 4 o'clock I have to rise. I have to. I have an interaction with judicial officers. Yes, 5.
Section
Please.
5, my lords. The section 5, my lords. I'm reading it again, my lords, for my
Yes.
satisfaction. The
Yes.
central government shall also formulate a national policy in consultation with the state government and the state commissions for rural electrification and for bulk purchase of power and management of local distribution in rural areas through panchayat institutions, users associations, cooperative societies, NGOs, or franchisees. The mandate assigned is to the central government with aid and assistance of the state governments and the state commissions, my lord. The APDCL, which is a distribution licensee, has no role to play, my lords, when it comes to formulation of this policy.
No, that can't be accepted. That
the
submission can't be
franchisees-
accepted.
My lords, why I'm saying this, my lords, for a simple reason, my lords, because I believe there is an attempt to show that, my lords, the agreement in question is of a statutory nature.
No, not that. But there are documents to say that he is a what you call the yes, page 21.
Page 21, yes.
First line is, whereas the party agrees that the second party may undertake the management of local
lords.
electricity distribution network.
I'm not disputing that, my lord.
No.
I'm saying, my lord, this franchisee agreement has no connection whatsoever with section 5, my lords.
Okay.
Because the mandate assigned to under section 5 is assigned by the central government to the state government with the aid and assistance of the state commissions, my lords. It does not go on to say that distribution licensees like the APDCL should also enter into franchisee agreements to cater to rural area or local area electricity requirements, my lords. For that very reason, my lords, section 5, in my humble submission, won't be attracted in the present case.
You wanted to say something?
Understand, Lordship will not take up any.
Because
other
at 4 o'clock I'll have to rise.
My lord,
Ah.
there is one matter, Lordship, recollect that matter pertaining to that cement factory, my lord. It
Yes.
is in the list. So
Okay.
today is not tomorrow, my lord. Second half, my lord.
tomorrow, I don't know,
They have got the instruction of.
Yes, madam. We have. More this time because madam. I have a received instruction, madam. They need 2-3 days to provide us the complete instruction, madam.
3 days
Can it
more.
be on, madam?
Then let it be on Friday. Right? Friday, my lord.
Friday.
My lord, item number,
Just give to the court master, ask
Yeah,
your junior,
we-
ask your junior to the,
yes,
ask your junior to give it to the court master.
on Friday, my lord.
Item number 58, madam, that can also be taken up in the next, madam.
Just tell the court master because,
Your lordship, they may go for fresh tender, your lordship. Let it come, but till then, no fresh tender, your lordship.
no, for that I have to hear, because I can't
Yeah,
divert my
yeah,
mind.
yes,
If I am to pass an order, wait for some time
I am waiting.
before rising. We'll take it up. You just ask, who's for the respondent, ask them to be here. Whoever is for respondent, ask them to be here. Yes.
Section 5, my lords.
You're saying that this distribution has got nothing to do with section
the
5.
national policy formulated under section 5, my lords. This is to my, with the instructions that I've received, my lords. After the trifurcation of the AACB, my lords, into the APGCL, the AEGCL and the ACGCL, there was a requirement, there was a lack of manpower, and there was also a lack of local area knowledge, my lords. For this very reason, franchisees who belong to the local areas were roped in through these agreements to cater to the electricity requirements for metering, for billing purposes, and for dispatch and collection of the revenues, my lords.
No, then, because that I'll accept only when you file an affidavit to
My
that
lords, I
effect.
can file an affidavit to that.
Because without that, it's very difficult to accept because of the fact that in your agreement, why would you write the issue of franchisee?
My lords.
So this is a word which appears nowhere else. In the act, is it there in anywhere else about the franchisee?
Yes, definition is there.
There's a definition, my lords, that's from section 2, subsection 27.
No. That is only a definition.
Definition.
Substantive section where franchisee is envisaged, except for section 5.
I could not find it, my lord.
So therefore, this franchisee must be read. So that, well, unless you can show that under the ARC regulations code or under the rules, you are permitted otherwise to have a franchisee divorce section 5. Then I would accept your submission.
My lords.
Otherwise, without an affidavit, this is a submission which I can't accept.
Otherwise, because the section 5 otherwise is clear, my lords, to that effect, my lord, because it does not include the term distribution licensee, my lords.
It can be read otherwise. You see, it says that the national policy will be made in consultation with the commission and state. Therefore, if this policy has come, we must presume that there is a consultation process with the state and the AERC. Otherwise, this franchisee will not be implemented.
My lords.
The implementation itself goes against you. You will be prevented by the principle of estoppel to raise that.
My lords, I can file an affidavit to that.
Hmm.
I can file that. But I'll go on to my other arguments. my lords. The mandate assigned to distribution licensees, my lords, and the obligations of such distribution licensees like the APDCL is defined under section 42, my lords, duties of distribution licensees and open access. Now under this section, my lords, there is absolutely nothing that says that they have to enter into agreements with the franchisees or they have to execute franchisee agreements for carrying out the national electrification policy. There's nothing given here, my lords.
Pardon me, I didn't get it.
Under section 42, my lord, 42 defines the obligations or duties of the distribution licensees like the APDCL, my lord. These duties do not in any manner include execution of contract for rural local area managements or for executing or advancing the national policy of electrification of rural areas as defined under section 5, my lords.
42.
42, my lords.
So it's a difficult argument to accept.
Well,
You see, please come to section 42 again.
42.
This is what you are referring to.
Yes, Manoj.
It shall be the duty of a distribution licensee.
Yes, Lord.
A franchisee is not a distribution licensee in any way.
Section 13 is the exception. Manoj. But the
You see,
exception.
distribution license will only be you. Now, if you come to section 5,
5, Manoj.
5 says bulk purchase of power and management of local distribution in so and so. So management and franchisee are two different connotations altogether.
It goes on, Manoj, subsection 1, because it's not limited to subsection 1 alone, Manoj, 42.
And then you come to this section 13.
13, yes.
Now number 12, first 12. 12 says
yes.
authorized person to transmit supply,
Distribute.
no person shall,
Yes, ma'am.
correct,
Yes.
distribute electricity. So therefore, even in section 5, you don't say that you distribute and you are distributing it. It says management.
Management.
And then come to 13. And it says unless he is authorized to do so by a license issued under section 14 or is exempt under section 13. Now 13 is the appropriate commission may, on the recommendations of an appropriate government, in accordance with the national policy formulated under section 5 and in public interest, direct notification that are subject to such condition restrictions, if any, and for such period or periods as may be certified in the notification, the provisions of section 12 shall not apply to any local authority, franchise, so-and-so, cooperative society or franchisee. Therefore, franchisees is an exception carved out under
Section 5.
13, read with section 5 and read with 42.
Respectfully, Manoj, for that exception to hold field and to apply to the present case, Manoj, the role of the APTCL might be required to be there, Manoj, in categorical terms under section 5 or section 12 or 13 for that matter, Manoj. Because it says appropriate commission, which again is the AERC, and the appropriate government, Manoj, which in the instant case is the state government. The mandate
No,
is
you
assigned
see,
to
as
them.
a common man,
Manoj.
people know the agreement which they are entering into. It's a organ of the state,
Yes.
100% what you call a state-owned entity.
Yes, Manoj.
So people will not have a distrust on the APDCL to enter into an agreement only to find out that the APDCL will change their stand and say that no, this agreement itself had no basis.
No, I'm not saying that the agreement itself has no basis, Manoj. It is not. My submission is it is not a statutory agreement, Manoj. It is not a
can't be.
statutory contract for it to be enforceable under Article
It
226.
can't be. You know what will be the effect? You see, it will have two effects. Number one, this person page para 20 who has done this agreement he goes into a soup. He jumps from here to a from a frying pan to a fire. Because you have not prosecuted this person from having an agreement and implementing it. So therefore, once you protect this person, this is the second aspect. Second aspect is once you protect this officer, that means there is a ratification of the agreement by you. You are aware of this.
Yes.
Even today you are aware of it. You may not be aware then, but now you are aware of it. That is the second part. There is another third part.
Yes, ma'am.
Wait. If you deny this agreement, then you'll have to also show that the AACB, as a matter of policy, engage these persons, your own staff, to do the job which the franchises are doing. Correct.
I'm sorry, madam.
You see, I outsource my court master to X, and X is now working as my court master. Now, if I deny that I ever engaged X to act as a court master, then I'll have to also show that my own court master, who was the appointed court master, was in fact doing his duty. You must have engaged someone. You can't say that, well, I am distributing it. Bill, I don't know. Somebody will take care of it.
There was a process in place, like I had said, Manoj. When after the trifurcation, there was a lack of manpower.
No, that's okay.
Then these
No, that
agreements
is,
came into
no,
being.
that is okay. But that means there is a ratification to that agreement. You come back to number one.
I'm not disputing the agreement or the existence or the validity of this agreement. That is not my stand. I'm saying it is a non-statutory agreement, hence not enforceable under Article 226. They can very well go ahead and file a claim for damages. but for enforcement is
Just tell me, which tender, fishery is there, but with this tender business we are handling, which tender is a statutory tender? It's a realm of contract. Why we are entering into 26? Why we never become wise earlier? So you see, every contract must be done on the strength of some authority. Because that's what I said. Number one, you did not dispute the authority of the person to enter into an agreement. You have not prosecuted him. Therefore, when we lift the corporate veil, because you are again a company, corporate veil can be lifted. Once that is lifted, that means you are working in tandem. You don't employ your own persons. You agree to this agreement. You allow a third party to do that job. So therefore, when we lift the corporate veil, it's a corporate decision which is being implemented.
Yes, ma'am. It's a decision, of course, madam. That is not
So
what I'm disputing.
once it's a corporate,
There was a decision, a conscious decision taken by the APDCL for reasons of lack of manpower.
then
and
merely
lack
that,
of-
then merely because an agreement, you see, let us test your argument in a second manner. Now, was it possible for the AACB or the APDCL to enter into a contract, divorce section 5? Could you have done it? Assuming you don't agree to a franchisee, could you have done that agreement? So you see, by this argument, your two arguments fail. Number one, that there was no franchisee. under section 5. This is not a franchisee within the meaning of section 5. That would fail.
My lords.
And this argument also would fail because of the fact that there's an agreement, it's a tacit approval to that agreement. So you can't, because now if I deny this, then the automatic fallout would be that it's an agreement within the meaning of section 5. Then you are trapped by your own argument. If you raise this argument, I'll have to answer it.
My lord.
Once I answer it, you come into the trap, you fall into the trap. Because what would be an agreement if it is not within the meaning of section 5, because you could not have done it then.
To bring those facts on record, my lords, I'll have to file an affidavit, my lords.
Yeah, fair
That I can do, my lords. Within a day or two, I can file an affidavit. But I can move on to my other.
Yes, definitely.
But this
Go
is
ahead.
my, otherwise an argument that I frame, my lords. It's not a statutory contract, hence not enforceable under Article 226, my lords. And even assuming it is a contract flowing out of Section 5, merely saying so won't be enough, my lords. The agreement itself has to contain in the instant case, the mandate of Section 5 or 12 or 13.
Cannot accept. You
Okay.
can't take advantage of your own fault. You get washed out there. You enter into an agreement, you don't say your power, and then you say that it is not there, therefore it is illegal. It is taking advantage of your own fault.
On this slide, my lords, I'll rely on this judgment, my lords. 2022 1 SCC 401, my lords. 2022
Just
1 SCC 401, my lords. JP Kensington Boulevard.
Just
I'm sorry.
I was referring to section 5
5,
plus 12
13,
plus 13
plus 42.
plus 14. Yes, now,
I'm sorry, but this was
20?
a voluminous
It's okay.
judgment, so I could not get a hard copy.
no, it's okay, 20.
2022 1 SCC 401, my lords. JP Kensington Boulevard Apartments Welfare Association. Kensington Boulevard Apartments Welfare Association and others versus NBCC India Limited and others. The judgment rendered by Honorable 3 judges bench of the Supreme Court, my lords.
Just a moment. Twenty
2022, my lords, 1 SCC 401.
1 SCC 401.
Yes.
JP Kensington Boulevard Apartment Welfare Association.
My lords. And others versus NBCC India Limited and others.
This is a bankruptcy case, right?
Bankruptcy case. There was also a question with regard to whether or not an agreement can be, by its very nature, can be a statutory agreement, while placing reliance on a judgment that dealt with the electricity law.
Which paragraph?
Para 140, my lords.
Yeah, just a moment.
Sorry.
Okay.
140, my lords. Page 581. For the portion in italics, my lords, placitum D. At page 581, my lords.
142. 141,
140, my lords. It's
140, yes.
140. At page 581, my lords, it continues. Starts from placitum D, my lords, at page 581. The portion in italics, my lords, merely because a contract is entered into in existence of an enabling power conferred by a statute and by itself cannot render the contract a statutory contract. If entering into a contract containing prescribed terms and conditions is a must under the statute, then that contract becomes a statutory contract. If a contract incorporates certain terms and conditions in it which are statutory, then the said contract to that extent is statutory. A contract may contain certain other terms and conditions which may not be statutory of a statutory character and which have been incorporated therein as a result of mutual agreement between the parties.
Same thing.
This is again with regard to, my lords, power purchase agreements under the electricity law.
No, that is
For
okay.
distribution and
No,
interstate-
that is okay, but you are arguing with the presumption that section 5 is not applicable.
Assuming section 5 will apply to our case and
Then becomes a statutory agreement.
for it to become a statutory agreement, my lords, the mandate of section 5 for that matter has to be followed, has to be enshrined in the agreement, my lords. And that is what the agreement, this portion of the judgment says, my lord.
No, I'll tell you why. That is a problem. I forgot the facts of this case. It is too lengthy. And what you call you see, what happened was that this company was put into liquidation. And there were this resolution process undertaken. Now there are several agreements which crop up in this. And then under the what you call the
IBC, my lord.
no. Yeah. This in that para 140, it refers to CA. That is
Contract
CA is no. CA is concession agreement.
Concession agreement.
CA is construction agreement that you will find in the initial paragraphs. There's a reference to this concession agreements. Now this, what you call para 140 also, you get a UP Act of 1976. What is that? I don't know.
As even I am not aware.
Correct. So therefore, and here what had happened was, if I remember it correctly, there's some jumbling up in my mind. You see, this Japan. There's some foreign investment also in this project. Yes, that you will get in if you are having a book. If you can just you see in the just give it to me. I'll recollect them. Give that book to me. There's this concession agreement I forgot. Ah. Yes, now I get it. Yes. Yes, you come to paragraph 141, that will explain it to you. The contract in question, the CA, even though not statutory one, is nevertheless a contract entered into with the concessionaire and statutory authority, that is YEIDA. It is needless to observe that even if the scheme of IBC or resolution plan could modify the terms of the contract, any tinkering with the contract in question, that is the concession agreement, could not have been carried out without the approval of the consent of the authority considered, that is YEIDA. Correct. Any doubt in that regard, since quelled with the reference to section 37 of the CIRP regulations, which requires that a resolution plan to provide for various measures, including so and so, the authority concerned in present case, IDA, is one established by the state government under the UP Act of 1976, and its approval remains sine qua non for validity of the resolution plan in question. Correct. Now you get an idea what is happening. That agreement, although you are reading one paragraph in isolation, but here what had happened was that the resolution plan was there, that agreement was entered into, but they did not have the consent of the authority, and under, because of section 37, it says it's not a statutory contract. Because the approval is sine qua non. Because I did not read in the context of your case. Just cursory, if I have the book I read, it's a casual reading I'd made. So I'm not very sure with what I've understood of this judgment, but the main thing is that if it is not statutory, the essence lies here in 141.
Approval.
Approval is not there, but I can't say I'm not very conversant with the facts of this case.
No, it's with regard to the development of the Yamuna Expressway.
This is only casual reading. The book was SCC comes and I just flip it. That is all. That is all I know about it.
So my submission would be, even if assuming section 5 applies to the present case and the franchisees or the agreement with the franchisees were executed in furtherance of section 5 of the mandate thereunder, for the agreement to be treated as a statutory agreement, the mandate or what the section 5 says has to be incorporated in the agreement. Or for that matter, section 13, like my lord said, pointed out. As such, the agreement, in my humble submission, is not a statutory contract and not enforceable under Article 226.
You still fail. This specific relief act is a very beautiful book. You again fail under a specific relief act. You can find out the reason why. Why will you fail under fail in this argument also? Can you find out the answer?
Section 31, 34.
See section 26.
Rectify, yes.
Correct. So you did not apply for any rectification. So therefore, so far you are concerned. This agreement is never a mistake. Reverse argument against them would be that since it was never pointed out,
was never
Mr.
pointed
Chaudhary
out.
would says that
I was coming
you,
to
you,
that.
you never pointed out that it was not a valid agreement. Because you see, you can take one more defense, which you have not taken. The other defense is that number one, that the contract must be executed by an authority competent to do so. Therefore, unless you can make an argument that, well, the corporate seal was not affixed to that agreement, therefore it's not a contract agreement. But that argument will also fail. Because you take advantage of it. And once you take advantage of your own agreement, you can't turn back and say that, no, it's not there, because then what applies? Section 73 applies of the Contract Act. Once you take advantage of their agreement, then you can't come out of it. You're taken advantage. You can't come out of it. I will continue some other day, but today is the last day.
Yes, that's another point I would like to make, Manoj.
This has to be extended for 7 days at least.
I just point out one thing, Manoj.
That's what I
There's-
also,
there will-
page 57, now.
There's a expression in the termination notice itself, no longer commercially expedient, Manoj. I've sought instructions, I've received instructions, Manoj. May I just place them, Manoj, for my lord's consideration? And this is very relevant, Manoj, because we are a public company, Manoj, we are responsible, we are using public funds, Manoj. By executing and carrying out with the present agreements and the franchisees, Manoj, we are losing money. Like I had pointed out, Manoj, these franchisee agreements were executed because we had a lack of manpower and we had a lack of local area knowledge, Manoj. Now thereafter, there has been recruitment and we've now come to a position where we have people in place who can carry out this works. Now, by doing this, we can save a fixed sum of rupees 4,22,000 for this very circle itself. Now, there is a chart to that effect, Manoj, at page 10 of the instructions. Now, these are the 8 franchisees before my lords. Under the Karimganj.
Okay, I have to rise because the judicial officers are waiting. In fact, I'll take it up tomorrow morning at 10:30. It will not be in the list, but you make that submission. But tell them today they will not be terminated. Tomorrow, don't oust them.
Okay.
Tomorrow they will not be ousted. The
At 10:30, I'll make a mention.
It will not be listed. Mr. Chaudhary, we are here at 10:30. But instruct them that they will not be ousted. Well, I have to understand what you are trying to say. I'm keeping it.
Tomorrow is 10:15, I think.
Tomorrow is 10:15. Tomorrow is 10:15. And Mr. Mazumdar, your matter can't be taken up today.
Can it be day after tomorrow, your lordship?
Day after tomorrow will accommodate.
I can not 50 and 50.
Okay. I have to address the Judicial Academy now.
Yeah, I mean,
No, I'll do it from here, but the time is fixed.